Item number 37. For order. Well, what is this? Well, this is in respect of a review block. The Lordship has had it on some occasion, and Lordship was pleased to issue notice in this matter. That was at the last of that was on 10/26. Lordship was pleased to fix it for final hearing and disposal. Hearings are already completed in this matter. Why should we appeal? Lordship on the last occasion it was not, it was left over. Try to put your Lordship has fixed it for final hearing. That is the subject of my Lordship. Sir, review. No, Lord. Item number 4, Lordship. I want to withdraw, Lordship. Item 4. Your name?
Yes or no?
Mr. A. Sharma, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the incident with petition. We appear. And that is on behalf of the state of Assam. And Mr. A. Bhattacharjee appears on behalf of the Revenue and Disaster Management. Taking into account the above, the requisition is closed. What?
With the liberty, Lordship.
No liberty. What is the matter about?
Related matter, Lordship.
Huh?
Some documents are required by the government. So we have to fresh file it again. So
No, then we have the matter witness. No liberty witness.
Obliged.
Don't come up with liberties only at the time when the matter is taken.
Yeah, please, Your Lordship. I beg to make a mention for listing of an item for motion on Wednesday, Your Lordship.
And I'm paying for it after vacation time. Pending. Matter pertains to my lord, jurisdiction of an FIR. Henceforth. After vacation. 30 April. I'm paying for date on 30 April. Such a long date, why? Because it might come up, my lord, randomly, instead of randomly, my lord, if it is on a fixed date. Absolutely no. If comes up randomly, you should be happy. You mention a matter to get the matter listed, not to fix a date on a particular day. Sorry, cancel. Next. Please proceed.
Victim is item number 13, Lordship. I am appearing on item number 13. I am appearing on behalf of is audited Lordship 24 to 3. 4.
What do you want?
Pass over for the day, Lordship. Better maybe takes 4 or
Item number?
13. On there.
At the request of who are you?
Yes, ma'am, on behalf of Ahmed.
Huh? You are not there in the list.
Yeah.
Sorry.
On last date, that is 26th, Your Honor has directed us to file an additional affidavit for the petition, for putting up in record of petitioners and uncle's NRC. But since the petitioner is not there, we are not able to file the addition.
We'll look into it and map it.
Lordship was, it was on the last day when it was listed, Lordship, I was given liberty to file an addition in affidavit because there was a lack of details on the part of the petitioner's Lordship. Lordship, today we are going to file the additional affidavit Lordship because on last Friday, my client has received some instruction, Lordship, and been waiting outside to sign the affidavit, Your Lordship. After some time, maybe Lordship, or maybe on Wednesday, Lordship. Or may take up at 4, Lordship. In the meantime, I'll try to bring the affidavit on the top.
What is your case?
Lordship, if Lordship comes to the to the judgment, Your Lordship, where the direction is there, Lordship, page 36. In view, Lordship, the last paragraph, 37, in view of the discussion Lordship, if may I even allow to give a gist of the matter, Your Lord.
Yes, now what is the grievance?
The gist of the matter is that Lordship, on 24/7/2018, Lordship, the district administration, the DC, has issued an order whereby one ABC has been appointed to look into the affairs of the Thakurbadi situated at FRCB.
That has been set aside.
Thereafter, on 16/8, Lordship, on 16/8/2018, that ADC has constituted a committee comprising of some individuals, Lordship, which are not officials, they are individuals of the situated area. And those individuals, on the strength of the 16/8/2018 order, they have instituted a committee. And they are functioning with the committee, they are managing the affairs of the Thakurbadi. Both the orders 24/7 and 16/8/2018 are stayed by the Honorable Court during the motion. Thereafter, but this committee was still functioning. They were collecting rents, they were interfering in the matter, as it means like they are the holders of the premise. Thereafter, the petitioner has filed an contempt. Thereafter, the district administration started taking action that these orders has been stayed. Therefore, there should be strict compliance of this order. Therefore, and the district and the police commissioner have been informed to take necessary action to maintain peace and harmony in the area. Thereafter, in the meantime, they are still functioning, Lordship. It is in the undisputed because I have records, Lordship. Thereafter, the final judgment has come up, Lordship, whereby both these letters were set aside. And in the meantime, Lordship, this committee has instituted a separate committee saying it is a Sitaram Thakurbadi trust. Thereafter, this trust is still functioning. And on the strength of the 16/8/2018 letter, they are still functioning. This judgment has come up, Lordship, in whereby this category, the 16/8/2018 letter is set aside and quashed. But still they are therefore interfering.
So it
We
is
have-
a dispute between you and them, not the government.
Yes, Lordship, but there are issues, Lordship. There are issues, if I may be allowed to.
We are
bring on
filing the
record-
contempt against whom?
Contempt against the DC also, Lordship, because.
Why?
Because in 2024, an incident has occurred between the original Pattada, that is the petitioner, and those persons, Lordship. And during that, the circle officer came in and he locked one of the rooms and he took the keys, and
That's a subsequent cause of action.
that was during the pendency of the writ petition. Your Lord.
Maybe that's a subsequent cause of action.
Yeah, the subsequent cause of action is that the keys are not yet been returned, Lordship, though this,
Was there any direction to return you the keys?
no, Lordship,
Then-
but that was covered, Your Lordship. It is
Maybe.
impliedly means that.
No, there's no implication, there's no direction to that effect. Here, the direction is that these two orders, where 27/4 and so were set aside. And the DC was only directed to, however, so may exercise his power and authority for maintaining law and order.
Lordship,
That's all, nothing more than that. Because the basis on which the court interfered were only on the ground that, look here, the DC has no business to interfere with the internal administration of this particular aspect. Now, therefore, anything is there, go and file a suit.
no, Lordship, if I may bring your Lordship, like you say, additional remedy is not there, Lordship, I would have
No.
bring your attention to the impugn order of 16/8, Lordship.
No, 16/8 has been set aside.
Set aside, but
So-
on the strength of this letter, Lordship, that committee is still functioning.
Understood. So therefore, they are functioning illegally.
Yes, Lordship.
Absolutely. But by way of a contempt, we can't look into that. And neither you can look into anything out there. You have to go and file a civil suit.
That I agree, Lordship, because there is a disputed question of facts, Lordship, I understand. Lordship, then one more thing, Lordship, I may an extra. Lordship may come to Lordship.
File civil suit.
No, Lordship may come. Lordship, what happened, Lordship, in the meantime also, those individuals.
No, Mr. Das, you have to understand one thing. On one hand, you are taking a plea the district administration has no business in a earlier round of litigation. And therefore, the passing of the order dated 24/7 and 16/8 is absolutely without jurisdiction. Now, let's aside it, saying that the district administration has no business. Now, the court, however, did not direct that those persons who are exercising the control or whatever may be, that they should remove and give it to you. That is not the direction passed by the court. But impliedly, forget about implied. Implied cannot work in a contempt proceedings. So therefore, if you are agreed by, by an authority exercising a jurisdiction who doesn't have the jurisdiction, it's a private dispute, go
That
to the
is
civil
my
court.
submission, Lordship, my big, Lordship, when the foundation is gone, Lordship, that is 16.
Division bench.
The later part
Contempt
also,
appeal,
the
division
later
bench.
part.
No,
is
sorry.
not for the Lordship.
No, sorry, nothing doing.
Lordship, and Lordship, one more aspect, Lordship. In the meantime, those individuals has without, behind my back, they have cancelled my patta. And that has been Lordship
That is
challenge.
again another subsequent cause of action. These things cannot be looked into, Mr. Counselor, sorry. The dismissal,
Lordship may, after hearing the additional affidavit,
no, from here, what you are planning, what is contained in the contempt petition cannot go beyond what is mentioned out there in the additional affidavit. It is a private dispute between you and those persons, and you want now to bring the DC.
I have made those individuals. as well to the court.
Understood, but now you want to bring the DC. In between a dispute between you and them,
Because the DC on the stand,
whatever may be,
This
is
is
there as of now that 24/7 document and 16/8 document is not enough.
it's not that. Then the committee also then.
So that is a subsequent cause of action which you need to take it up with before the civil court, not before this court, because you have taken the plea that they have no jurisdiction, it's a private dispute. And therefore the court held, yes, it is a private dispute, and as such the DC had no business. Very well. If you take that and take out the DC's power, now you want to invoke the DC to remove these people. How is it possible? Tell me. When there is not a single direction that those usurpers or alleged usurpers out there had, cannot also have to hand over the control to you. Very not to,
Lordship, that was my only thing, your Lordship. If the DC has no
no,
power,
sorry.
then on what stand, Lordship, this committee is still functioning, your Lordship?
Understood, very well. It cannot. But that is a private
Private
dispute between you and
Lordship, my only prayer, Lordship, may this thing that true Lordship, after looking at the additional, Lordship, after looking at the additional, I'll try to bring on record by,
you have a copy of the edition.
Yes, you can get, but only one copy.
You look in.
Yeah, I'll just mark.
But while I peruse the additional affidavit, you just think into whether you would like to withdraw or should I get it dismissed. That's it.
Lordship, yes, Lordship. Actually, there is a 1 year limitation is there, Lordship. That's why there is the issue.
What limitation?
Lordship, Lordship may come to the first annexure, your Lordship.
What limitation?
Lordship, the 1 year limitation, Lordship, the judgment was of 25/2/2025. Then I filed it, okay, just before the limitation, your Lordship.
So
If Lordship, if I withdraw the matter, there will be no liberty.
for filing contempt.
No.
You don't have the question of filing contempt does not arise. It is only the question out there you may very well go, and for that limitation is there. Because it's a continuing cause of action and therefore you can very well proceed. You still have limitation of 3 years for seeking a declaration.
Lordship, if Lordship comes to,
Which paragraph?
should not paragraph, Lordship, I would like to bring to the annexure, your Lordship. Lordship, annexure, A, Lordship, there will be annexure A. So Lordship, this is the order of the DC, Lordship.
So these have been satisfied.
This has been set aside, Lordship, and thereafter, Lordship, the annexure B.
68 has also been set aside. Okay, then
Then Lordship, there are subsequent, there is a judgment of seven, the title suit of 7 of 1986, whereby the land was given to me, to my father, and thereafter, Lordship, and that trust has been dissolved, Lordship, the trust that is functioning now.
Understood.
No private dispute.
What do you want now? Withdraw or limited dismissal?
I'll leave it to you. I'll leave it to you, Lordship. Whatever, Lordship.
Right, Mr. So-and-so, the
Because
legal counsel
I'll be approaching the trial court, Lordship.
Oh, yes.
Yes,
No,
that's
no, I'm making it very clear that the filing of the dismissal of the AR shall not affect your rights. Make it very clear.
Yes.
Heard Mr. So-and-so, the legal counsel appearing on behalf of the petitioner. There is an application filed under Section 12 of the Contempt of Courts Act 1971. Read with Article 215 of the Constitution of India, alleging willful and deliberate violation to the order dated, to the judgment dated 25/2/2025, passed in WPC number 5616 of 2018. It is relevant to take note of that WPC number 5616 of 2018 was filed challenging the actions on the part of the district administration in passing the order dated, in issuing an order dated 24/7/2018, and well as another order dated 16/8/2018 by the additional deputy commissioner, additional district magistrate, Kamrut Metro. These two orders have been set aside by the learned coordinate bench of this court in the impugned judgment and order dated 25/2/2025. The reason why such the impugned order, the orders dated 24/7/2018 and 16/8/2018 have been set aside by the court is on account of is on the finding that the district administration had no authority and or jurisdiction to pass such order, taking into account that the affairs of Sri Sitaram Thakurbari is a purely internal affair of the said religious denomination, and the district administration therefore had no authority or jurisdiction to pass the impugned orders dated 24/7/2018 and 16/8/2018. Paragraph number 37 of the said judgment being relevant is reproduced herein under. In the backdrop of the above, if this court duly takes note of the contempt application as well as the additional affidavit which have been filed, it is the grievance of the petitioner that though the orders dated 24/7/2018 and 16/8/2018 have been set aside by this court, but a committee so formed still continues to function. And as such, it is an apparent, it's a willful and deliberate violation to the order, to the judgment dated 25/2/2025. It is the opinion of this court that upon Setting aside the orders dated 24/7/2018 and 16/8/2018 by the court, by the judgment dated 25/2/2025, the said order ceased to exist. Under such circumstances, if any person continues to exercise such power subsequent thereto, it is not only a separate cause of action, but it relates to the internal affairs of Sri Sitaram Thakurbar, which can only be agitated by filing a suit, by approaching the competent court of civil jurisdiction, and not by way of filing a contempt application in the instant case. Under such circumstances, this court does not find the instant contempt application, but find merit in the instant contempt application for issuance of notice, for which the instant application stands rejected. Next. It is, however, observed, before parting with the record, this court, however, observed that the rejection of the instant application shall not preclude or prejudice the petitioner to approach the competent court of civil jurisdiction if so advised. Yes. Any instruction? It is only now. Whenever you get the money, you take. Yes.
Because it's my seniority much. Otherwise, it would be discrimination for the other four who are above me. So
Mr. M. Hussain do not object to me. Mr. M. Hussain, the learned counsel appearing on behalf of the petitioner. Mr. You appear, Home and Political. Ms. Ken Borman appears on behalf of the Home and Political. Mr. Yusufia appears on behalf of the Finance Department. Ms. R. Chori appears on behalf of the Assam State Legal Services Authority.
respond 3
And Ms. Ken Borman appears for the District Legal Authority Services Authority. The petitioner herein is aggrieved by the delay in processing the petitioner's claims for victim compensation, which the petitioner submits, which is the claim for victim compensation. In terms with the Assam victim compensation, what is the name?
Assam Victim Compensation Scheme.
2012. The materials on record show that on 5/7/2025, the respondent number 4 have already passed an award that the petitioner is entitled to an amount of rupees 5 lakhs as compensation. The grievance of the petitioner herein is that in spite of the order dated 5/7/2025, in spite of the award dated 5/7/2025, the respondents herein have not released the said payment, and it is under such circumstances the incident with petitioner was filed before this court on 19/1/2026. This court, by an order dated 4/2/2026, sought for instructions as to why the payment had not been made to the petitioner in pursuance to the award dated 5/7/2025. Today, when the matter is being listed, Ms. R.A. Chaudhary, Mrs. R.A. Chaudhary, the learned counsel appearing on behalf of the Assam State Legal Service Authority, that is the respondent number 3, have placed an instruction on the aspect of disbursement of the amount of rupees 5 lakhs to the petitioner. The said instruction is kept on record and marked with the letter X. A perusal of the said instructions reveal that though the petitioner herein is entitled to the amount of rupees 5 lakhs, but on account of inadequate dispersal of funds by the state authorities, the said amount could not be paid to the petitioner. It is further mentioned that the District Legal Services Authority disperses the amounts on the basis of priority criteria and chronological order. And at present, there are 4 other claimants above the petitioner, and the petitioner would be paid immediately upon receipt of the said funds from the state authorities. This court also heard Ms. M. Burman, who appeared on behalf of the state, who submits that upon proposal being received, the said amount would be disbursed to the District Legal Service Authority, Dhubri, so that the payments can be made to the petitioner. Taking into account the above, the incident with petition therefore stands disposed of with the following observations and directions. Over. The petitioner is entitled, petitioner, along with her dependents, are entitled to the amount of rupees 5 lakhs as have been awarded by the order dated 5/7/2025. The respondent number 3, 4, is directed to disburse the said amounts to the petitioner upon receipt of funds by maintaining the priority as well as the priority claim, by maintaining the priority and the chronological order. Number 3, the respondents, more particularly the Commissioner and Secretary to the Government of Assam Home and Political Department, is directed to release the funds to the respondent number 4. So that 24. As per the proposal submitted by the Assam State Legal Services Authority by letter dated 17/3/2026, so that the said amount would be disbursed to the petitioner. The said exercise be completed by the respondent by the Commissioner and Secretary, Government of Assam Home and Political Department within a period of 60 days from the date a certified copy is received from the petitioner.
Legal care, whether sample, protest and sworn and evidence, whether they authorize the petitioner to receive the amount. So I have annexed the.
That is, you go before the legal service.
Lordships, absolutely similar order, same district. Here, the petitioner is at serial number 3. And same order. Only difference is that she's at serial number 3. She's at serial number 3, Lordships. That's it.
Okay, we go ahead for the price.
As per the plan. DP of life.
The worship come to the last pair. On or before 24th, my lord. 9th is election, my lord. 10th is a holiday, then BO holiday, second king. For BO holidays, 2-3 days there.
Allow with interest.
If not, if it is
What was passed in the year 2018.
my lord, it says, my lord, there is some, the claim of the petitioner in regard to the share. The claim of the petitioner individually, Jitendra Sharma Gadunabha fought the circle of the ascended in the share regarding the acquired land, my lord. There are some formalities which have to be done, my lord. That's why it is taken time. As per the instruction they have provided to me. They'll be releasing it by 24. If by not 24th, my lord, let the interest come. Because till 9th, my lord, there is election. 10th is a holiday. Again, be a holiday schedule.
Pursuant to the order passed by this court on we issue notice. Issue notice.
Let it be come on 25th. If not, it's released before 24th, my lord. My lord.
We issue notice.
Otherwise, 25th, I think he's agreeing to release the amount for 24th.
You take back your instructions. You don't want to press the instrument petition, we dismiss it.
No, my lord.
Without notice, I'm not going to issue, asking to do anything.
Then
You
Lordship,
take back this.
Lordship issue notice. No, no, Lordship, just pray, my lord. It's a prayer.
You dismiss. Your notice was issued to you on 7/1/2021. You have approached in the year 2025.
No, my lord, in
And
between,
then after that, immediately you have approached this court.
no, my lord, in between, my lord,
I think we-
Lordship, kindly see, Lordship,
You cannot come here like
Lordship,
this.
just look only one letter, man, only
No,
one
I
letter,
think
man.
there is no-
Page 25, kindly see. This is their exercise they have contemplated on 31/12/2025. Finally, my lord. The old
No,
documents
this is
they have
different.
collected.
Now these are things being done out there. You were asked to come out there. Go there. Why should we?
My lord, as per their requirement, everything has been done. They call us, document submitted, and finally, my lord, page 25,
No, Mr. Counsel,
their
here is
contemplation.
a case that you have, with reference as the owner to submit hearing the share report and so and so. Now, you may issue the notice in connection of their aforementioned project for onward submission of the deputy commissioner and receipt their award. This was given on 31/12/2025.
My lord, prior to that, they have called us, we submitted all documents, etc. After this final report, they have submitted for release of the payment, my lord.
So,
So therefore, my lord, now they
did
have,
you go on 2/1/2026?
no, my lord, afterward, we have approached to them, my lord, also requested a submitted letter. Since no action has been, lordship kindly see another 25, and they have released the amount. There are 2 lanes they have acquired. This has been released, but it has not been released, my lord. And 25 will also be approved for this honorable
You
court.
were asking for division on 2/1/2026. And then immediately on 17/2/2026, you have
Page
approached this
25,
court.
Page
I
25,
think we should not entertain this type of.
let me, lordship clarify the 25A,
Nothing.
there are 2 land acquired.
No.
Out of also be approved before this honorable court, that writ petition was disposed of. On the basis of this, my lord, direction, the payment was made. But so far 25, my lord, the payment was made.
So therefore, we should not issue notice, we should dismiss the petition.
My lord, that will create, my lord, more problem for us.
No problem.
My lord,
Go
kindly,
there. Nothing.
the lord, issue notice, my lord, no problem. It's
No.
my only prayer, my lord. Lordship
No,
will take
you
it otherwise.
said no notice. Without notice, I don't do
Then
anything.
lord, issue notice, my lord.
Issue notice making it returnable on 4th of May 2026. And why you kindly see this, your document, why should we at all issue notice? There were 5 applicants.
Yes, sir.
You say that kindly divide this compensation amongst the 5
Yes, sir.
in 4 equal parts. Why the other persons are not made performer?
Yes, sir. Thing is that, my lord, so far these are the all family members, my lord. Then earlier, my lord, the same occasion, we distributed the all amount, my lord. Now only 2% opposite, doesn't mean, my lord, that the rest are recorded.
You should have made them performer.
My lord, we don't want any amount from their side, my lord. Once suppose this amount would be disbursed to us, equally that will also disbursed to them, my lord. And earlier also be opposed before authority all
Because
together.
you say,
We are
kindly
common,
see-
my lord.
no, kindly come to page 26A,
Yes, but there are 2, my lord, these are the two
last
parts.
paragraph.
Understood, my lord. Thing is that at
I
the
didn't
time of
know, we
lordship,
dismiss it.
lordship kindly see.
Non-vendor of necessary.
Lordship, kindly sit for a moment. Lordship, allow me to submit, my lord. My lord, once the document has been called all together, we approached before them, submitted all documents, my lord. They finally prepared the report, 31.
You on 2/1/2026, you ask them kindly divide this amongst 4 of us.
Absolute, my lord.
Then immediately on 19/2, you have approached this court. Do you know what has happened in the
Kindly see,
meantime?
My lord, once we approach before them, they are not responding anything, my lord. That's
Where?
my lord.
When did you approach? They are not
My lord,
responding.
kindly see. This is the
After,
letter.
after 2/1/2026, where is your representation?
My lord, one after another repentation serve no good purpose. We personally oppose them, my lord. They are showing that this and that ground, that the officer is not there, sometimes the mandal report is not there. These are the things they are showing, my lord. We are facing problem, my lord. And that's why, my lord, earlier we also approached before this honorable court by way of writ petition in respect of.
You do
as
one
a-
thing. You in the meantime, put it to the court. Send the money to the court. Let them do, the court do, decide in reference as to who is entitled, because we cannot pass a direction, taking into account those persons are not here.
Technically, my lord,
Technically,
Kindly
this is
see,
the
my lord.
thing.
suppose if required
So don't
performer
make
to
these
make the
type of
party, my lord,
submissions.
we'll make the party, my lord, no problem, my lord.
No. You have made the submission, wrong submission before this court, don't issue notice. So therefore, take the trouble.
Or lordship,
You make a reference of
lordship, kindly see, my lord.
as to who is entitled to the court. It will be done in similar terms with section 31 of 30 of the Land Acquisition Act 1894. You do it and then proceed with it. Let the court decide, and in the meantime, you deposit the money in the court. That is the best. You dispose of it.
My lord, this is not the way, my lord. Kindly let me submit my lord.
Submit.
So far, my prayer is concerned, lordship. Kindly, lordship wants to that first stage that we have to make the proper dependent. Lordship, I am the person who has been agreed, my lord, being the shareholder, my lord. Then definitely I will appoint for this honorable court. So far, suppose if they have,
You on 2/1/2026, you make a request to them.
yes, my lord.
Then look here, divide it amongst 4 persons.
Actually, today also we are standing same position.
Understood? So thereafter, if they have not done, where have you approached them?
My lord, afterward, personally we approached before them, my lord. It is not a case that we have not approached before them. That's why, my lord, I made a statement, my lord. I have kindly say. I made the statement that afterward too also be approached before them.
Where?
My lord, beg up, sir. Kindly see their position, lord. See how they are conducting their affairs in the office, my lord. Persons is running pillar to post, my lord.
They have issued you a notice in 2021. Kindly come and take that here. You, after 4 years, you wake up and go. Kindly give us.
Kindly see that after 2021, they are showing that these and that grounds are there, these records are required to be called, my lord. Ultimately, they have called all records, we have submitted everything.
Issue notice making it returnable on 4th of May 2026. Mr. A. Vatsadi accepts notice on behalf of the respondent number 1. Mr. Shivadas accepts notice for respondent number 2, 3, and 4. The grievance of the petitioner hearing is that the petitioner, the land of the petitioner have been acquired under the provisions of the Assam Land Requisition and Acquisition Act 1964. And the payment of the compensation have not been made to the petitioners. This court finds it relevant to take note of Annexure 4 to the petition, wherein a representation has been submitted to the Deputy Commissioner, Kamrup Metro, wherein the petitioners have sought for payment of the compensation after dividing the same into 4 parts and to distribute. It is the case of the petitioners that after submission of the said representation, no effective steps have been taken. And it is under such circumstances that the petition was filed on 17/2/2026. The record revealed that this court had sought for certain instructions from Mr. Endas, the learned counsel who appears on behalf of the respondent number 2, 3, and 4. In pursuance to that, an instruction has been placed before this court to the effect that effective steps are being taken, but on account of the announcement of the model code of conduct and the ongoing and the elections to be held to the Legislative Assembly of the State of Assam, the respondent would be taking steps. There has been certain delay, but in all likelihood, the compensation will be paid to the petitioner on or before 24/4/2026. Taking into account the above, the respondents. Accordingly, are directed to taking into account the same instructions so placed. This court observes that the pendency of the instant proceeding shall not be a bar on the part of the respondents to disburse the compensation to the petitioner, as well as the others who are entitled to, taking into account that only two persons have approached this court. And the representation so submitted specifically mentions that the compensation is required to be disbursed among four persons. In the circumstance, no, the amount is not disbursed on or before 24, on or before the next day, the respondent shall bring on record their stand as to why the amount has not been disbursed, and further, who would be responsible for the delay, so that appropriate orders can be passed in that regard. But next time, don't try your luck with this court. Yes.
Six, my lord.
Study your case.
Some more time is required, my lord. Nine. Okay.
Yes, where the land has been settled in your favor.
No, that is at page 16, my lord. Reference column, my lord. Tahir, son of Shumab. Tahir is the petitioner.
How much? 1 bigger. 1 big. Then
Thereafter, my lord, without giving us notice, my lord, that has been cancelled and recorded in the name of Assam Power Distribution Company. Yeah. That is at page 17. Starts from 16, my lord. The reports of, so name of Abu Tahir. Abu Tahir is deleted. Yes, sir. Page 16, my lord, last line, name of Abu Tahir. Next, my lord, deleted. And thereafter, my lord, name of Assam Power Distribution Company. Inserted. How? Now, my lord, we are evicted. Thereafter also, my lord, as we do not have any alternative plan.
now tell me, where is the document by which your name was inserted?
Hello?
There, when there is an allotment cannot directly go into the record of rights. It has to be first a document of allotment. Where is your document of allotment?
Of
allotment was not here, but it is, we applied and accordingly, my lord, applying this provision of land policy 2019, my lord. And was
How? How? So there has to be some order somewhere.
that is not available with me, my lord, this key document.
No, it cannot
Now,
be.
my lord, how it can be done,
Okay, okay, tell me. After the name has been inserted in your name,
my lord?
did you pay any? Because, did you pay any khazna? Bring khazna.
That I am to take instructions.
So it appears it is not a patta which has been issued. It appears to be a wrong insertion in the patta.
It,
You have not paid the premium.
whether I have paid the
So
premium or not.
therefore, that is your case. You have not come up with this
No, my lord,
the
that-
instruction to the prefect.
That I did not ask for, my lord.
You
On the
should
other,
have. You should have.
My
So
I did not ask for, let me
Very bad.
obtain instruction, my lord, but one thing is this, my lord. And is recorded in my name, and patta has been given, that is the on record, my lord. If the authority also may commit some wrong,
we have it on Wednesday. Produce the patta. Produce the patta, produce the land payment, revenue payment receipt. You have made the payment of premium as well as the allotment. There has to be an allotment first. If the allotment is there, thereupon you make the payment. After that, the patta would be issued. Once the patta is issued, then the name of is corrected. It cannot directly be corrected. It's possible.
No, there has to be.
Now, what is your instruction?
Well, firstly, well, they have said for some time. Some time is required for the execution.
my lord, let the government
And-
also
and, my
obtain
lord,
instruction.
And,
How-
well, this is basically cancellation of, even if it is assumed, well, if cancellation of pacha, then well, they have a remedy under 147. They have a remedy under 147.
But if you don't follow 26, if you don't follow 26, this court can very well
That,
exercise to
That's-
26. So no problem
that's,
with that.
that's,
And so therefore,
Let me-
making that technical objection has no relevance.
let me,
But the fact remains as to whether there was an allotment at all.
allotment, what?
First, second, did you make the premium? If you have not made the premium, then no, therefore your name could not have been, the land could not have been allotted to you.
Regarding allotment, my lord, allotment may not be, my lord, but premium is to be given. Premium is to be given.
No, allotment has to be made wherein it has to be mentioned, okay, as per Vasundhara's whatever scheme may be, you are therefore being allotted. And once you are allotted, you deposit this particular amount, and if you deposit, your name would be correct.
My lord, let me obtain instruction.
Wednesday,
No, no, no.
this is the matter again on Wednesday, enabling the
Wednesday.
petitioner.
Witness day will be short. Witness day will be short. My lord, 1 week
Thereafter, you
time-
will say elections are coming.
my lord,
You want it after 10 months, no problem. We can give it, but no interim extension. Wednesday, interim extension.
not Friday, my lord.
Friday, court is closed. That is why you are saying. It is maybe Good Friday for others. It may not be Good Friday for you.
Detected by on Monday, my lord.
And then no interim extension. What do you?
Okay. By witness day.
You just obtain that instruction. Because
why
if
the- why
that
the
is so,
premium was-
it appears, because what it appears from your document is there seems to be nothing mentioned. How it came? You would have definitely, a petitioner would have enclosed that document, first and foremost. And secondly, the petitioner would have shown that I have made the premium payment. That is not there.
But yes, I have gone through some other document that PM is paid by so and so.
Absolutely. So
Sama.
therefore, once
And
that is
thereafter.
there, so it seems, there seems to be some
Without premium, my
correction,
lord,
something wrong, because you see, one has to understand. The insertion in the record of right does not confer a title of anything or demolish the title. So insertion of PDCL's name also, it does not create a title. But the fact remains as to whether you have been at all allotted. You may have a different case. That look, yeah, I am there, I have filed an application out there, the settlement is processed. My name was also inserted, that's a different thing, but I cannot be thrown out without giving me a process, giving me anything. But this is maybe something they may have realized, otherwise they would not have made this. List the matter again on Wednesday, thereby enabling the counsel for the petitioner to obtain instructions as to whether any order of allotment was issued in respect to the land at measuring 1 bigger covered by tag number 283 of Miyadipatta number 176, and further as to whether land was whether any premium was paid by the petition pursuant to such a law.
The petitioner, not only one petitioner, there are three petitions.
By the petition. No, okay. Whether may be petitions. You get that instruction, Mr. Mr. Okay, you get that instruction. Once you get the instruction matter, we immediately interfere saying that they have not taken action under Rule 26 and therefore we set aside the action. Don't worry. But if you don't have, you dismiss your interim order pastoral shall continue till the next day. We also make it clear, I don't do like this. I could not. Issue notice making it returnable on Wednesday to be good. One. On 1st of April 2026, Mr. Dina accepts notice on behalf of the respondent numbers 2, 3, 4. So accepts notice on behalf of respondent number 1 and the Pitipata accepts notice on behalf of respondent 5. Extra copies of the requisition will served during the course of the day. The grievance of the petitioner herein is that the petitioner was allotted a plot of land at the petitioners were allotted a plot of land at measuring 1 bigger, which is covered by tag number 283 or patta number 176. And their names were duly recorded in the record of rights. However, all of a sudden, the names of the petitioners were struck off and the name of the PDCL was inserted. It is under such circumstances the petitioners have therefore approached this court by filing their instant petition. During the course of the hearing, this court inquired with the learned counsel appearing on behalf of the petitioner as regards the letter of allotment of the land in question, and further as to whether the petitioners have paid any premium, which is the requisite for allotment. The learned counsel submits that he would obtain necessary instruction and place the same on Wednesday, on the return of the date. Taking into account the above, the interim order pastoral shall continue in the next day.
Regarding only one petitioner, your lordship mentioned, there are three petitioners.
Third petitioners, only petitioners. But there is only one land.
There is some difference.
2 plots
On three because
they have mentioned 2 plots.
three petitioner number 3 is in occupation of three because.
No, I'm going to, where is the allotment?
Allotment is there.
How many?
But the allotment was made for petitioner number 1. Then petitioner number 2. But petitioner number 2 died, my lord. In place of him, he had Sapra. And now petitioner number 3.
This is total 1 bigger.
Not total 1 biga. 1 biga for petitioner number 1. Your lordship would be please thus.
What are the tag numbers?
Schedule to the revision.
No, let us see the document.
Your lordship would be.
1 biga to Abu Taher.
Your lordship would be pleased to see. Schedule A. Schedule A 1 biga. Schedule B 3 biga.
They have mentioned page 21 for 3.
Page 30.
Petitioners have been allotted lands. Under the Assam land policy of 2019. In the case of a petitioner number 1, 1 biga of land was allotted. Which was biga of land was allotted from government doc number 770, which was subsequently converted into tag number 283 of Miyadipatta number 176. In the case of the petitioner number 2, the petitioner number 282D, their father was allotted a plot of land at measuring 3 biga from the government tag number 117, which was subsequently converted into tag number 270 of Miyadipatta number 121. Subsequently, both these lands, in both these lands, the names of the petitioner as well as the father of the petitioner number 282E were struck off, and the name of the respondent number 5 was inserted. This court considered during the course of the inquiry inquired with the learned counsel as regards the payment of allotments which were issued to the petitioner prevailing, as to whether any premium was paid which was requisite. They mother passed earlier shall be.
I'm sorry to disturb your lordship. Here, my lord, petitioner number in the name of father of petitioner number A, B, and C. All right. And petitioner number 3, he has own name, S21.
Let's say 3 biga.
Name is 3. All right.
Yes, what is the next page?
Your lordship. I am in possession of 6 lectures of land. And why the impugned notice?
Where is the notice?
Page number, your lordship.
Page?
Yes. Page 15, lord. Page 15.
Huh?
15. Page 15, your lordship.
Why do you mention it as 39? This is 29.7. Why do you say 37?
That is very good. Earlier to this notice, your lordship,
Where is the earlier notice?
page 16, your lordship. Earlier, they forwarded notice asking me to appear in the office with document in support of my claim. Accordingly, we appeared in the office, Your Lordship, and submitted some documents, Your Lordship. My grievance is that they did not provide me any enough opportunity to explain my position. Only they received my document. And I was waiting for further hearing. Though they verbally told that we will be called later on, but no further hearing was fixed. And suddenly this improved notice came. And my intention in this petition is that actually my land, which I am in occupation, is not actually government land, Your Lordship. It was a annual pattern. And the possessory right were transferred to different persons, and subsequently I purchased the possessory right.
The council, let's see your deed of sale.
Yes, Your Lordship.
Kindly come to page 20, the schedule. Why you are saying to be annual patta land is categorically mentioned as only.
It relates to, yes, yeah, that number is different, Your Lordship. 669, not 97. They are claiming that it is a DAG of 97 government land, but earlier it was a DAG number 669, and it relates to another sale deed, Your Lordship. Kindly, page 22, Your Lordship, Annexure D. We purchased this possessory right from one Sri Ram Chakari Lal. I have annexed, and in the schedule, it is mentioned it's annual patta number 114. Actually, Proceed revenue was collected from our deed, to whom the original patta was allotted, Your Lordship. It was never a wasteland.
Is the Tozi,
Yes, if page, Your Lordship, page 34. Annexure 35 is in vernacular form. I have translated it. So it was a general category of them. It is mentioned.
but this is Tozi.
Yes, Tozi.
This doesn't refer to annual patta number 149.
But I claim that it relates to
You
my.
make claim many things. But the fact remains that this is not the land which we are referring to.
This is the land actually.
Cannot be. This is 264.
It is Tozi, Your Lordship. Tozi
Understood.
number.
264.
Yes. Lord.
And you see, these are all other DAOs which you are saying, if you have paid for annual patta,
Yes.
it cannot be Tozi.
But subsequently, Your Lordship.
Do you know what is Tozi?
Yes.
What?
So if some particular land is allotted for me, and they are collecting revenue from me.
No. Tozi is a form of penalty for staying in government lands. That's the law. I don't know if it has changed in the meantime, but
Land policy, Your
2
Lordship.
weeks back, the law remains it that Tozi is to be paid against the land which had been. Now, annual patta, the revenue cannot be a Tozi. It is impossible.
But since Your Lordship, since the land possessory right of the land was sold to different persons, certainly there is a breach of condition of annual patta. So a person cannot, in fact, cannot transfer his land under annual patta to others. So there is a breach of conditions. My contention is that my land was not previously recorded for any public purpose. This my particular plot of land ownership. So my contention is that I'm not encroaching.
Mr. Counsel, an annual patta land can very well be transferred. This
Yes,
is-
Lord.
it is dependent upon the vendor and the vendee.
Yes.
And the transfer is good between the vendor and vendee.
Right.
But it does not affect the right of the government. Because the government has granted him the lease. If the government allows you to permit him, that's a different thing. But this particular person, as against, it is not binding on the government. There's a difference between that. An annual patta land is good. If Mr. A. Bhattacharjee sells it to you, fantastic. There's no problem. You can very well claim a right against him. But you cannot claim a right against Mr. Borua, taking into account that the government.
But your
The
lordship,
concept of annual patta land.
I agree your contention, your lordship. But the category of the annual patta, my land is not previously reserved for any public purposes.
Not necessary. It's a government land.
So. there is
Rule
a
18
provision, your
categorically
lordship,
says, Rule 18 categorically says,
Land for
a Rule 18 to categorically says it will include even a government parcel, a wasteland, any other land, which was earlier not there, but in 1999-97 they have added that. So therefore, a government wasteland also would come within the ambit of it. You may have a right of claiming settlement over the land
Yes,
or
your
taking into account the land policy. It's a
Right,
different
right,
aspect of the matter.
right.
That if it's a government wasteland, you can very well claim it. But the moment the land is being reserved subsequently also, then you cannot question, because it is the policy of the government how to use the land in whatever manner it may. Yes, the government cannot say that, okay, I don't like his face, I would not give it to him, I'll give it to her. Government can't say that would be arbitrary. But the government, if it does it for public purpose, in respect to any land that, okay, now we require it for the TB hospital, then no case. You may be given some other land somewhere, because you cannot have a right. If you see the land policy also,
Land policy,
14.3 of the land
yes, sir,
policy,
yes, sir, I have gone through, sir.
it
there
categorically
is a-
mentions that a person who is in possession does not have a right that he has to be bound.
Nowadays, your lordship, nowadays, annual pattas are not being issued nowadays.
Obviously, because
And
now
there is a provision in the land policy, your lordship.
this has changed from 1989 on. There shall be no annual patta issue.
Like that,
Continuation of the annual.
but some provision is made in the land policy also, your lordship, regarding the annual patta.
But you don't have it in annual patta. Annual patta, if there's a sale out there, that's a different thing, but it is not binding, as I say, with the government.
There is that,
But the government has to again initiate a non-renewal notice.
there is a big respective provision of this land policy regarding the annual patta, your lordship. I have another copy.
First of all, you show that you have an annual patta.
So I have purchased the policy.
Where is the annual patta? He writing out here, Mr. Bhattacharjee writing out here that I have a selling my annual patta. First, you show me that a patta has been issued to him.
If you permit your lordship, there is a provision,
Yes.
land policy 2019, 11.2. The government may examine the matter where transfer of annual patta land has been given effect by the original pattadas to some other persons against the existing provisions. I cannot transfer my annual patta to outsider, even it is not transferable to my legal heirs also. So provision is made here, your lordship. If government may examine matter where the transfer of annual patta land has been given effect to by the original pattadas to some other persons. So I am other persons and patta is transferred to me against the existing provisions. Yes, land is transferred against the existing provision. Government will evolve a suitable mechanism to deal with such land so that no land remain under annual patta. And the provisions for conversion from annual patta into the periodic patta. There is another important mention, note, a direct observation is made, note, there is a note. There shall be any restriction to convert annual patta in town for individuals So I'm in annual patta land. So there may be settlement with individual who may not be the actual original patta. This provision is made here. And this is to be done by the district commissioner, Your Lordship. And my case, circle officer has issued notice to me asking some documents in support of my claim. Accordingly, I raised the claim that my land is not a purely wasteland. Previously it was a annual patta land. So my case might be taken differently. So
Show me a document whereby annual patta was issued to that your earlier person. Even a land payment receipt of the vendor to do. Where is,
I need some time. I will collect from the original.
then this is not there. If you have, you should have
Yes.
given it there. Why
Yes.
should we state?
Another, sir, Your Lordship, same matter earlier came up in this honorable court to be a writ petition. So if you permit me, then I will submit an order. So my adjoining neighbors, they challenge this particular impugned order, my adjoining neighbors. So it has been set aside by this court. Your Lordship, I need this much and nothing.
Did you approach this court earlier?
I was not the party, sir.
Then how do you get the benefit of this order? Because this order, the court interfered with on the ground. That look here. There was a specific direction passed in the earlier round of
Right, right.
litigation
Yeah,
that
yeah,
the
you're
deputy
right.
commissioner should issue a hearing. Now here the notice has been issued by the circle officer.
Right.
If that be so, this was done by a person which had not been conferred with the jurisdiction to do
Right,
so.
Your Lordship. On that ground, yes, right. This I need Your Lordship for the temporarily I may be protected, Your Lordship. Temporarily I may be protected.
How? Give me a good reason. Why should I protect you? Yes, Mr. Barua, what do you say?
Lordship, first of all, he has challenged the notice in a belated state. It was issued in the month of July 25. And at present instruction, whether he has been evicted or not, that instruction I do not have, Lordship. And from the notice, Lordship, that impugned order 3725, it seems that hearing was given, verifying that all the documents and all, Lordship. And the thing he is
We do one
claiming,
thing, we do a notice.
and otherwise, Lordship, that tag number 97 is reserved for the TB hospital. And
know
he is claiming that it is annual patta. This is different area, Your Lordship, not different. Lordship.
We do one thing. You send an instruction next week.
Lordship.
We have it next week, no thing. Simple it next. Because if nothing has been done, he says that on 37, 2025, nothing has been done in the case of the petition. Till date. So nothing happened.
Yes, sir. Yes, sir.
You cannot have an apprehension now during the election, so you won't be too. Issue notice making it returnable on. Seven?
Immediately after the vacation.
No, I'm not passing an intake.
Lordship, Lordship.
You obtain that instruction as to whether the petitioner has been evicted or not.
Instruction.
That's it. Nothing more than that. Because here, the moment I give a stay, we have it consequences.
Lordship, Lordship.
And as to whether a personal hearing was given to the petition. These are the
That
two
two
instructions.
things, Lordship.
Issue notice making it returnable on 8th of April 2026. Mr. Esa Bolwa accepts notice on behalf of the respondent number 2 and
2 and 3.
Mr. A. Vachaji accepts notice on behalf of the respondent number 1. The petitioner have essayed the order notice dated 37/2025. Recorded below, and the notice dated 29/7/2025. Second election A to the petition, whereby the petitioner was asked to vacate the land within 15 days after taking into consideration that the documents which were placed by the petitioner were found not acceptable for settlement. More so when the government doc number 97 have been specifically reserved for the TB hospital. Taking into account the above, it is seen that almost after 8 months, 9 months, the petitioner has approached this court, alleging indefinite apprehension that he may be evicted. This court, the counsel appearing on behalf of the petitioner submitted, though the petitioner was provided an opportunity to produce documents, but he was not granted an opportunity for personal hearing. This court directs the state councils to obtain instruction as to whether the petitioner have in the meantime been evicted. And secondly, as to whether a personal hearing was granted to the petitioner before issuance of the interim notice dated 29/7/2025.
Much. Next one is also same, Lordship. Similar method. Eight also same, similar method.
Same date, 29.
Taken after something.
Okay. Here's what is the instruction.
After something.
Here's what is your instruction.
Lordship, may I please?
Will you demolish his house?
No, the demolition which was carried out, Lordship, it's on a different tag.
Some of the partners, lordship, many partners, they have willfully give up some portion of their land. And
So
eviction has already been conducted.
my house is demolished, but the proposed road has not yet been constructed through my cooperative.
Huh?
The circle officer intended to construct a route through my courtyard. That is not done. House is demolished.
But you agree that within that land, you say that land, the house where it was constructed is your allotted land,
Yes, Lordship.
or is it the government land?
It is allotted land, Lordship. Can you come to page 21? This is the allotment order, Lordship.
Yes.
One legal land was allotted in the year 1977, and since then, from the period of my father, we are living on that land by constructing dwelling house.
Okay. Then,
And the one Bonnabanga LP school that was shifted from the village Bonnabanga to this present place, and that is shifted behind my house also. And that Bonnabanga school is without any ingress and egress also. I allowed the students to pass through my landlordship
what is annexure 8?
in Annexure 8. Lordship. Page 33.
Is this the road?
Yes, sir, Lordship, can you see the small post is here. This is the road covering the from my courtyard, Lordship. And subsequently, the houses were demolished. Lordship, this is the photographs I have next is 36 onwards. On humanitarian consideration, Lordship, I allowed the students to pass through my courtyard during third season. Lordship. Through these years, this was going so, Lordship, but as the new school management committee has come, it started a route through my courtyard. That I refused. Then they filed an application.
Also tell me one thing, page 33.
Page 33. Yes, Lordship.
On the left-hand side, there is a tin house. On the right-hand side, it seems to be an RCC construction.
Yes, Lordship. Pakka house. Pakka house, Lordship.
Now, both these houses have been demolished.
All the houses on the land is demolished, Lordship. Not only these two, Lordship.
So you say that this to be a part of dock number 456.
In the, on the said tag number, the house is constructed. Lordship.
So dock number 456.
Yes, Lordship.
Because your Patna land, which was issued, was in respect of dock number 456,
456.
isn't it?
Lordship.
One of the 456. Now, tell me whether this particular statement which is being given you say that the construction has been in dock number 1. Now, the eviction is in dock number 95 and 96, not in dock number 456.
And this dock number 456, if your lordship go by the Chita copy, it is also shown as Sorkari. The second one, the first one is 96, I think, doc number 95 or 96. 96, and second one is, yes, Lordship, that is 244, new doc number 244.
That number. Old is 456, new is 24.
New is 244.
So you cancel the allotment.
That, from that Sita copy, Lordship, it's shown as Sarkari, whether it is cancelled or not, that is not in the.
But you have not denied that the land has been allotted.
Yes, Lordship, this page number 23. Sorry, 21. That doc number 1.
Then in your instructions, it is mentioned that the land has been allotted.
Keep this document.
Unless you cancel the allotment, right is there.
But that from the first paragraph, Lordship, it is shown that in doc number 95 and 96, the eviction was carried out. This
Which is not a part of doc number 456.
seems to be.
You do one thing. You file an affidavit on this villa. Issue notice, file an affidavit.
Lordship.
There shall be a status quo in respect to doc number 456.
Lordship.
Now doc number 92 of the two.
Lordship.
Issue notice making it returnable on 4th of May 2026. Anybody accepts notice on behalf of the respondent number 1 as regards the respondent number 2, 3, and 4. Mr. H. Sharma accepts on behalf of the 2, 3, 4. 2, 3, and 4. Stock copies of the petition will be furnished to the legal councils by tomorrow. As regards the respondent number 5 and 6, steps be taken by way of speed post by tomorrow. In addition to that, liberty is given to the petitioner to effect service upon the respondent number 5 and 6 by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. The petitioner shall ensure that the service upon by way of dusty upon the respondent number 5 and 6 is completed on or before 27th of April 2026. The case of the petitioner herein is that the father of the petitioner was allotted a plot of land at measuring 1 bigger, covered by doc number 1 of 456 and renumbered as doc number 92 of 244 at village Duba, Circle, Lokipur, by an order dated 25/1/1977. Upon the said land, the petitioner's father, as well as the petitioner, have constructed houses. It is the specific case of the petitioner that there is a school run by the respondent number 5 and 6, which is behind the land of the petitioner, and a road, a 4-feet passageway was being used by the students to ingress and egress to the school. It is the grievance of the petitioner that the respondent authorities have carried out eviction over the petitioner's land, thereby demolishing the petitioner's houses standing thereon. Over the allotted land. And it is under such circumstances the petitioner has therefore approached this court by filing the present petition. This court really takes note of, and takes note of the order dated 16/3/2026, wherein instructions were sought for the government council In pursuant to the said instructions, so pay instructions in pursuant to the said order, Mr. H. Sharma, appearing on behalf of the respondent number 2 to 4, have placed certain instructions to the effect that the eviction was not carried over the land of the petitioner, the allotted land of the petitioner, in doc number 1/456, renumbered as doc number 92/244. On the other hand, the eviction was carried out in doc number 95 and 96, which is the government land. It is the opinion of this court that these instructions be placed by way of an affidavit by the respondent authorities. So that the petitioner would have a chance to reply if so advised. This court further takes note of that by the order dated 16/3/2026, there was a direction to maintain status quo. And it has been submitted by the learned counsel for the petitioner that though the houses have been demolished, but the passage, the road is yet to be constructed. This court have also given an anxious consideration to the fact that the petitioner herein claims right only in respect to doc number 1/456, which have been renumbered as doc number 92/244. And there is no claim of right in respect to doc number 95 and 96. Under such circumstances, it is the opinion of this court that there is a requirement of passing certain interim directions. Accordingly, this court directs the respondent authorities not to make any construction over doc number 1/456, which have been renumbered as doc number 92/244. Or village Ubuduba within revenue circle, Lokhipur, in the district of Walpara, Assam. This court further directs the respondent number 3 respondent number 4, 3 and 4 to take effective steps for carrying out a demarcation as to whether the land wherein the demolition was carried out was in doc number 92/244 or in doc number 95 and 96, and place the said report along with the affidavit to be filed by the respondents. The affidavit, respondent numbers 2, 3, and 4. The affidavit be filed on or before 30th of April 2026. I think this matter,
Our what, my lord? Our maintenance has been able to agricultural land and thereafter they started filling up the land bylaw without any notice. No notice has been served to us, my lord. Therefore, on last occasion, my lord, we have to put it person status quo order and
Land have been acquired.
actually, what happened, my lord, they just come and put some bamboo stick in a huge area where our land is also there. And thereafter, they started to filling up the land half, my lord. And when we approached, nothing has been informed us, and no notice was served to us, my lord. So therefore, we had approved for this honorable court.
Yes, Norman?
Lordship, because of this election, Lordship. Because of this election, Lordship, this is the,
What have you done? Elections, what has happened?
Lordship, they are praying for some time because of this election, as because all the persons are involved in election duty. That is the,
Well, we issue notice, status quo is there. Yes, ma'am. Issue notice, making it returnable on. You want it after the new cabinet is formed or prior to?
it's better, Lordship. Otherwise, I think they will do the same thing, Lordship.
Issue notice making it returnable on 13th of July,
Lordship.
2026. Mr. N-Board accepts notice on behalf of the respondent one. Mr. H. Sharma accepts notice on behalf of the respondent number 2 and 3. Lordship. Extra copies of the petition be served upon them during the course of the day. The petitioners herein are owners of various plots of land, as has been detailed out at paragraph number 3 to the petition. The grievance of the petitioner herein is that the respondent numbers 2 and 3 have taken certain steps for demarcating a part of the petitioner's land by putting red color bamboo pillars. The petitioner is yet to be informed that any process of acquisition is being initiated. And there is no mention as to why these red color bamboo pillars have been inserted, have been put. It is the case of the petitioner that if acquisition proceedings are to be initiated, the same has to be done by following the mandate of law, that is by issuance of notice, which is a prerequisite. This board duly takes note of that by the order dated 23/2026, this board sought for instruction from Mr. H. Sharma from the learned government entity as to why certain identification marks have been put in the lands belonging to the petitioners. However, there has been no instructions. Mr. H. Sharma, the learned counsel who appears on behalf of the respondent number 2 and 3 submitted that on account of the elections to the Assam State Legislative Assembly, the matter be deferred till the formation of a new cabinet.
Lordship,
You
that
see,
may not be. No,
Sir,
no,
that
Lordship,
is why you
that,
say-
that the view I have expressed, but that is not the instruction, Lordship. They are praying for some time because all the officials are involved, so that
you
is,
said no, therefore I asked you whether you want it after the cabinet or.
that may not be, Lordship.
Therefore, I'm fixing, no, we'll put it, you said. Taking into account the above, this court had therefore fixed the matter on, made the petition returnable on 13th of July 2026. in as much as the period of the present cabinet would end on 30/6/2026. The interim order passed earlier on 23/2026, thereby directing of maintenance of status quo in respect to the present. This court also directs that this court is also of the opinion that without following the requisite mandate as provided under the acquisition laws, no authority has the power to mark, insert any identifying marks accordingly. This court directs that no proceedings for any acquisition shall be initiated over the lands of the petitioner till the formalities are completed as is mandated under the acquisition laws.
It has been wrongly filed as a writ petition. It has been wrongly filed as a writ petition. It should have been an application under section 42 of the PMLA Act. Because here we have assailed the appellate order passed by the PMLA authorities. My lord, I want to withdraw it with liberty to file appropriate application. This is a wrong petition, madam.
Mr. M. Biswas, the learned counsel appearing on behalf of the petitioner submits that the petitioner would be well advised to withdraw the instant with petition with a liberty, without prejudicing, without affecting the petitioner's right to assail the appellate order of adjudication before this court under section 42. Oh, he has come against the adjudication authority. That the petition that Mr. M. Biswas, the learned counsel appearing on behalf of the petitioner submits that taking into account that the order, which is the adjudication order, which is impugned in the instant proceedings, is appealable under section 42. Because the section 26 of the Prevention of Money Laundering Act under the provisions of section 26 of the Prevention of Money Laundering Act. So and so.
I simply withdraw with because there are issues regarding that because we could not file an appeal at that point of time because the appellate authority was dealing with late notice. I just want to withdraw and file with liberty. But certain facts I have not because this observation may go against me.
I'm putting it in that manner only. I'm giving you the liberty there.
Before the appellate authority
Oh.
in Delhi.
Wherever you feel like.
Because the appellate authority in Delhi, my clients are from India. She's a lady. So, and the limitation period is also over for the appellate authority. They have seized my vehicle. Now they are asking FD to release the vehicle. I am saying, let it there be a bond. Against the bond, I will go. My lord, there are certain issues. That will be simple. My lord, let withdraw with file to 30. My lord, this observation, this way or that way, my lord. Because I do not have instruction whether she will go to Delhi and all this thing.
So then why you are withdrawing?
My lord, I am withdrawing because my lord, under section 40, the appellate, there is a notification that against order of PMLA authorities, it should go before a division bench, special division bench. That I have come to know only only yesterday I have come.
No. Against that, there is an appeal. Under 26. Against that, there is an appeal under 42 to the High Court.
Because yesterday night I got that notification, my lord.
No, that will come only against the appellate authority.
My lord, can this matter come up on Thursday, my lord? I'll just take some time to go through the things. But only yesterday night I have come across that particular notification.
I myself could not.
You have the act.
I have.
Go
Section
through.
42 I
No,
have
no,
seen.
you are challenging an order passed under section 8.
17. Section 17, I have. 17,
17 order
page number 35 and page number 111. Page
31.
35 and 111.
111 is different.
Page 111 is issued by the deputy director.
Kindly come to page 110.
110.
An appeal under section 26 of the PMLA Act against the order lies to the Honorable Appellate Tribunal PMLA, which can be accessed online to the Appellate Tribunal so-and-so or directly by so-and-so, so-and-so. We do one thing, Mr. Counsel.
Yes.
We dismiss it on the ground that this court, I am not entertaining it, and we have an effect. But as she has put the issue as that there is an alternative remedy, I give you 15 days time to file. This is the only way out. That is the only way out. As I am not entertaining it, this is what I'm.
That's the best thing.
That is the best way.
Otherwise also, madam, I have seen, because the invitation will kill us. So in 15 days window, we get, at least we get. Absolutely.
Understood. You put that,
I got the
this
point.
is the way.
I got it.
This is the way how you can get it, because if you withdraw, you will have a problem. Let me dismiss on the ground that I am not entertaining, because she has raised that issue of alternative effect cases. Mr. M. Biswas, the learned counsel appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the respondent number. On numbers 2, 3, and 4. Mr. K. Gogoi appears on behalf of the respondent number 1. The petitioner herein have assailed the order dated 3/10/2025, passed by the adjudicating authority under section 17 of the Prevention of Money Laundering Act 2002. The learned counsel appearing on behalf of the petitioner, the respondents, number 2, 3, and 4, submits that the petitioner has an alternative and efficacious remedy. And therefore, this court remedy, as provided under section 26 of the Act of 2002. And therefore, this court should not entertain, ought not to entertain, the instant writ petition. Mr. M. Biswas, the learned counsel appearing on behalf of the petitioner, submits that though the petitioner has a remedy under section 26 of the Act of 2002, but it is really inconvenient on the part of the petitioner to approach the appellate authority, taking into account that the appellate authority is at Delhi. The learned counsel further submits that in the meantime, the period of limitation has also expired, and as such, this court should entertain, ought to entertain, the instant writ proceedings. This court have perused the impugned order dated 3/10/2025. And from a perusal thereof, it reveals that there are various disputed questions of facts which needs an adjudication. In addition to that, this court also duly takes note of that these appeals can be prepared online, as is very much mentioned in the impugned order dated 3/10/2025. It is also the opinion of this court that if this petition, if this court is to relegate the petitioner to the statutory authority, appellate authority, an opportunity has to be given to the petitioner to approach the said authority. Else, for the ends of justice. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. Number one, this court is not in this court, in view of section 26 of the Act of 2002, is not inclined to entertain the instant writ petition for the reasons aforesaid. Next, B. This court, however, observes that the non-entertaining that the rejection of the instant writ petition on the ground that it is not being entertained would not prejudice or preclude the petitioner to prefer an appeal before the appellate tribunal under the Act of 2002. In terms with section 26 of the Act of 2002. Number 3. It is further observed that if such appeal is preferred within 15 days from today, the appellate tribunal, PMLA, shall adjudicate the said appeal on merits without insisting on the question of limitation.
The present requisition has been filed.
Whenever you come up with such big matters, why?
But it's a very small matter. In fact, just a case.
So big. Yes, tell me, what is your case?
My lord, the present expedition has been filed challenging the illegal collection of the terminal charges by the railway authorities, my lord.
Huh?
By the railway authorities, the railway authorities have illegally collected terminal charges, my lord. My lord, in this matter, what has happened, our Honorable High Court, in two of judgments, have held that the railway cannot impose terminal charges apart from the 50 given goods sheds. And railway has been imposing in other stations as well, terminal charges, my lord. Subsequently, apart from that, my lord, our Honorable High Court judgment, an SLP was preferred by the Union of India. And it was placed before the three bench of the Honorable Supreme Court, and Honorable Supreme Court has dismissed the SLP preferred by the Union of India, my lord. And apart from that, my lord, according to section 199 of the Railway Act, whenever a rule is been passed, it has to be passed by both houses of the parliament. A central government cannot unilaterally impose a new charge or new rule without it being passed from parliament, my lord.
So in other words, you say
Yes, my lord.
that for the purpose of imposing a charge,
Yes, my lord.
or impose, you need a statutory backing.
Yes, my lord.
Statutory backing can happen if it be the law made by the state parliament or the state legislature,
Yes, my lord.
which is not.
This
As a basis of executive instructions, you cannot. That's your thing.
Yes, my lord.
Why so big?
My lord, the railway receipts, I have annexed the railway, 214 railway receipt. The claim amount pertains to 1 crore 34 lakhs. So I've just annexed, it is a railway receipt prepared by
Why
the,
you are not filing it before the railway claims tribunal?
my lord,
In view of the judgment,
yes,
in view of the judgment passed by the London Division Bench, why you are not filing it before the railway claims tribunal asking for a money?
my lord, there are two reasons, my lord. First, it being the case being an admitted one. Second, my lord, I'm also.
Understood, that is much easier for that.
Yes, my lord. Second, my lord,
Why should This court calculate what is the amount. This court can only give a direction that this imposition is not so proper and as such you have to get it. Whatever may be, this imposition has happened to be in this manner. So here, where is the impose for collecting terminal charges? Where?
Apologies, my lord. Where is the?
Because these matters have come up in appeal.
Yes, my lord, that has came
Therefore,
up.
the railways can lawfully depart with immediate charge for overloading if it is detected that the public stated influence. They cannot charge punitive after loading of the via at the destination. Therefore, I am taking the calculation correctly. After the. What are these orders for?
Lord, which?
These orders annexure so and so. Imposition of dates, page 38.
My lord, this is our honorable High Court judgment.
Therefore,
Yes, my lord.
therefore, go there.
My lord, what has happened? Learned Tribunal has declared this judgment as per you.
This position is not maintainable. This is just before its honorable court laws in their present form. Even if we cannot approve before the honorable court, there is strictly alternative remedies there. Section 13 of the Railway Act, as per section 39, even the recent judgment of the honorable apex court, we cannot.
My lord, in this matter, Learned Tribunal has declared our honorable High Court judgment as per incurium, my lord. Learned Tribunal, my lord.
Go there. Then again, let them come to this court and
Yes, my lord. My lord, the case being an admitted one, my lord. In a similar instance, my lord, honorable Supreme Court, railway matter only, my lord. I'm just placing it. Para 52, my lord. Judgment has been relied upon, my lord, which was subsequently overruled by the Supreme Court, my lord. I'm just reading, my lord, para 52. Yeah. The freight was initially being charged on an inflated distance rate as fixed by the central government.
Where you pay?
Para 52, my lord, page number 218. Rajasthan SCB versus Union of India. The freight was initially being charged on an inflated distance rate as fixed by the central government. Later, the freight was fixed to be charged on the actual distance. However, the railway continued charging freight as per the old inflated distance under the mistaken belief that the same was still applicable. The High Court prima facie was of the opinion that the refund of the difference of the freight was an overcharge and thus barred by section 1063 of the 1918. However, High Court relegated petitioner therein to avail statutory remedy, dismissed the writ petition, leaving all issues open for determination of the railway claims tribunal. This case pertains to, my lord, in 5-6 years, the railway collected excess freight, my lord, and the tribunal, High Court dismissed the writ petition on the ground that there is an alternative remedy. Subsequently, an SLP was preferred, my lord. Yes, my lord. Subsequently, my lord, an SLP was preferred in the pressing, in the next para.
I'm ready.
Yes, my lord. My lord, the Honorable High Court.
It has been admitted by filing.
Follow this, my lord. My lord, this is the Supreme Court judgment in this matter.
But the respondents are not admitting.
My lord, respondent has admitted in terms of section 191 of the Railways Act. Any document prepared by the railway authority would amount to an admission to the very fact that they have imposed certain charge. Thus, my lord, only the question is involved whether this is legal or not, my lord. And my lord, this collection is legal charge, not an overcharge, my lord. The learned tribunal is in respect to adjudication of the claims for overcharge, for compensation for loss, destruction, damage, spoliation of the goods, my lord. However, in my case, my lord, there has been an illegal collection of charge, my lord.
How do you know illegal collection?
My lord, this in the same judgment, Indian Oil Corporation judgment, which I've given, it's a reportable Supreme Court judgment at para 60.
How do we know that the amount you are entitled?
My lord, I've included the railway receipts, my lord. In the railway receipts, my lord, OTC and DTC, originating terminal station and destination terminal station, my lord. OTC and DTC has been mentioned, my lord. I've prepared a tabular form for the better convenience of the honorable court, my lord, on this registration. My lord, the tabular form starts at page number 5 of my petition. In the tabular form, I've mentioned the entire, given the extract of the entire calculation.
Which one page?
Page 5, my lord.
What is OTC?
Originating terminal charge, my lord. And DTC is destination terminal charge.
Both cannot be imposed.
Yes, my lord. Well, it can be imposed only in the 50 given stations, my lord. Only in the 50 stations all over India, my lord. As per circular, my lord. I've annexed the circular, my lord. Annexure 1.
Where? How do
Connection.
we know that it can be not be done here in these stations?
My lord, our Honorable High Court, in the case of Source India, which I've annexed, my lord, have held that it can only be imposed in the 50 given station, or as per this circular. And SLP was discussed by the Honorable Supreme Court. So, thus, any kind of collection would be illegal, my lord.
Then,
Yes, ma'am. So,
how do you know that it was done only in that state, not in the other?
Able to understand.
How do we know
Yes, ma'am.
that these are the only 50 stations they have done, not those others?
My lord, our Honorable High Court have held that and Supreme Court has affirmed that.
Kindly come to page 35, paragraph 10.
Yes, my lord.
Regarding the second question, there is no doubt that there are 50 specific stations having all the infrastructure for loading or unloading of goods. And if any of those 50 stations are used, then only the railway can charge terminal charges.
Yes, ma'am.
How do we know that these stations are not the 50?
My lord, page 28. The circular itself, page 28. The name of the 50 stations are being mentioned.
Where?
Page 28, my lord. In the tabular form, it's a part of the circular. My lord,
New Jalpaiguri, New Guwahati, Sansani.
good shades as per the zone wise has been mentioned in the tabular form. In the central zone, Jalgaon and so, your lordship is there.
Fellow, we dismiss your petition.
My lord, lordship, look upon section 191 of the Railway Act and 191. My lord, 191 is in respect to proof of entries and reports of the document. Entries made in reports and other documents of a railway administration shall be admitted in the evidence in all the proceeding by or against the railway administration. And all such entries may be proved either by the production of the records or other document of the railway administration containing such entries and or by the production of the copies of the entries certified by the officer having custody of the records and other documents. As per this section, my lord, the railway receipts, the terminal charges which has been imposed by the railway authority is a admitted case, my lord. Our Honorable Guwahati High Court affirmed by the Supreme Court has held that only in 50 stations it can be imposed, my lord. And my lord, the railways have been imposing all other goods shed as well, apart from this 50 station. The railway receipts which I have imposed is not covering those 50 stations. And hence, my lord, we legal charge.
Not going to the case. We will only question as to whether there is any imposition being made in the other 50 states. The problem which you are going to do is, you may reopen an issue which is closed. SLP dismissed is not an approval. Remember, it is it is not confirming. It's saying that we are not going to exercise our 126. Remember? Yes, ma'am. What you are trying now is to open up an issue which is closed. We take care of this. We can very well look into this issue again. You see, the reason why it is done is the 50 stations are there because infrastructure, if there is further infrastructure available in the meantime, then the section 73, if I'm not wrong, permits to collect on overcharge and overweight. Overloading. Now, if there is just for example, while coming from a particular place to another place, in the meanwhile, there is an overloading, then you say that you cannot look into it. Because section 73 says at any place. Only thing is, that when you are making the overload, and thereupon the correction is to be carried out, you have to be given an opportunity to leeway.
17.
That leeway right you have, that leeway is denied, then the overloading aspects cannot be taken. So at the time of downloading, they have to say that we have found that this is the overloading and this is why you have to go. And if that opportunity is not being given, then you can very well look into it. No problem. Here, the moment you are opening it, I think the union should be happy if I issue notice. Let us issue because the question is on the question of terminal, because we are not bound by this.
Yes.
Even the dismissal of an SLP, we are not bound.
Absolutely. That's not an issue.
But if a thing which you could not do it in Supreme Court, must be done here. So they will not only have a question here, they will also have a hope on the in a thing which is otherwise closed. Want to go ahead? You do.
My lord, in that case, my lord, I'll withdraw with the liberty to approach the tribunal, my lord. However, my lord, if lordship may just recognize certain observation, if the stations are not falling within 50 stations, it can be declared as illegal charge because, my lord, why? Because my lord, I'll have
No.
notice
You
under
want this? Why should I put a stamp of approval? Sorry, it is already there.
There was a jurisdiction is switched there. Yes, ma'am. Going to
jurisdiction, my lord. NFL is their jurisdiction, no, my lord. But 106, I'll have problem with 106, my lord.
No, you approach that. So you want to approach that, but the moment you do it, if this court opens up, I'm telling you, I have no problem issuing notice. They will be happy now to raise this issue and complicate it. And thereby none of this, all these terminal charges which is being carried out, they will keep on getting it. And they will again continue the same thing. Then what to do, you know. Yes, if you have challenge that in spite of that, the law is there, you are still insisting on the terminal charge. That is what you are asking. The moment you are asking, you are opening up issue which is otherwise closed.
My lords may permit me, I'll obtain certain instruction, my lord. Any date will be fixed for this matter. I'll obtain certain instruction.
You want a notice?
No, dismissal.
No, you should take a notice. Once you issue a notice,
Part was after tribunal decided it.
Mr. Gogoi, why you are not understanding? If I issue a notice, isn't the issue open to you for contesting again?
It's there also. Otherwise also if it comes to the tribunal, then also lordship tribunal decided the matter also. That's why his lordship for shortcutting it, he can't.
Yes, my lord. The tribunal is declaring it as a per inquiry. I'm not here to doing a shortcut business, my lord. It's a illegal charge, my lord. It's a clear-cut case of illegal charge, my lord.
Where the terminal done that?
Follow this.
Where the terminal has said so, it's per inquiry.
My lord, I have not annexed that order of the chief.
You have it?
My lord, I'll raise it at 2 p.m. my lord. I'll take it in focus.
How can the tribunal say?
Tribunal never said in the par inquiry lordship. The tribunal has discussed it lordship, even 2018 circular is come also. Last one.
My lord, if tribunal has not declared it as per inquiry, my lord, it will amount to misleading of the court. I would definitely bear loss with that, my lord. Tribunal has declared our honorable High Court judgment as per inquiry, which has been affirmed by the Supreme Court, my lord. In fact, 3 days before only, tribunal has dismissed the case, even though MFA 42 and 105 of the. And in a lighter note, we have been stayed that go to the High Court.
Third line. Third line, first line was 2018 circular. I'm not placing as because alternative remedies, I will argue on the part of the alternative remedy parties. And the issue they will just propose shares.
Now, Mr. Rafiq, tell me one thing. Why the learned ordinate bench have say that as regards the 50 stations, and
As regard to
why the learned ordinate bench say that against the 50 station, there can be imposition of terminal charges?
There's our honorable High Court judgment in respect to MFA 100, my lord. It's a judgment which is stating that facilities are mandatory, my lord. In terminal, facilities are not mandatory, my lord. Our honorable High Court judgment, which is stating facility is not mandatory, even if it is there in 50 or another 50. However, learned tribunal is stating that railway can impose.
No, I'm not on that. Here it says, regarding the second question, there is no doubt that there are 50 specific stations having all infrastructure for loading and unloading of goods. And if any of those 50 stations are used, then only the railways can charge terminal charges.
Yes, ma'am.
Meaning thereby you can, if it is done in those 50 stations. For other stations, railway cannot levy terminal charges. This is based upon a document, Railway Board Circular, dated 5/6/2007.
Yes, ma'am.
Now thereupon, in 2018, levy of terminal charges has been given to everybody. How do you take care of it?
My lord,
It means there are two aspects. The terminal charge can very well be imposed within the 50 stations. So the question of not imposing or not, which you made the submission, is not there. The terminal charge can very well be imposed as per the judgment of this court. But if you do it in those 50 stations, this the court must have come to an opinion on the basis of 5/6/2007. Now subsequently, this particular notification that so debit for both members shall be reimbursed in supersession of all previous instructions. The sanction of the competent authority hereby accorded for levy of terminal charges at ₹20 per metric on both inward and outward traffic for all commodities, including being handled at railway goods sheds and private freight terminals, both greenfield and brownfield, to be collected by the railways. So therefore, in view of this circular, it is not only limited to those 50. So therefore, the second question, which have been answered by the learned before, the learned court bench, appears to be without taking into consideration this document.
My lord, in this regard, my lord, I also have the certified copy of the appeal, which was referred by the railway, my lord. In that appeal, all these circulars was duly mentioned.
In terms of the rate circular, this is the rate of terminal charges to be collected by food trust for a matter has been examined. The rate of terminal charges. In the respect of the terminal charges. Now, Mr. Counsel, Mr. Gogoi, tell me. The rate circular 5/6/2007.
Was superseded by that particular sum. 18,
Which one?
18.
18. 18 supersedes
All the sir, all the
5/6/2007.
circulars. for families.
And what is this in 2019?
I think in respect to only 4%. Earlier it was not there.
And what is this circular of 88?
You see,
The terms and conditions notified at the rate circular. This is rate circular.
let's say,
We are not concerned. So therefore, to limit it only to this 50 states,
No,
no longer.
all the accounts. Then also the history is there. 2011 to 2014, that terminal charges is by the central government. After 2017, after that, it was again revived in 2000. That's why 2018 circular is come.
Had not been passed by both houses of the parliament. It has not been passed by both houses of the parliament.
Flooding,
This terminal charge by now, it's a rule which has been brought by the railway authority by a delegated legislature in the form of a circular, my lord.
they are challenging the circular.
My lord, I have not challenged that circular.
How do I look into that?
It has, my lord, it can be
Not
passed.
challenge the circular, na?
Yes, ma'am.
Then,
That was not.
then,
I'm here only in respect of the petition.
what to do?
My lord, I'll withdraw it with a file. I'll file it before the railway claims tribunal.
Is the only problem.
Fine.
Mr. D. Rathi, the Learned, Mr. D. Rathi, the Learned Counsel, appearing on behalf of the petitioner, Mr. K. Gogoi, the Learned Counsel. Learned CBC appears on behalf of the one and two. The Learned Counsel for the petitioner submits that taking into account that the claims so made in the instant petition as regards the refund of an amount of rupees 1,20,050, 1,34,50,602. On the illegal collection of terminal charges upon the petitioners during the period from 2020 to 2025. Would require certain adjudication of facts. And as such, he submits that the petitioner would be well advised to approach the Railway Claims Tribunal. He therefore submits that the petitioner would therefore not like to pursue the instant proceedings without prejudice to the rights of the petitioner to approach the Railway Claims Tribunal. Taking into account the said submission, the instant petition stands closed on withdrawal. Liberty, the withdrawal of the instant petition, however, shall not increase the petitioner to approach the Railway Claims Tribunal for permissible action.
I'm grateful, man. Much of.
Don't open things, it is closed.
Much of.
Yes, what is the case?
All that way. Accordingly, police and request to be circular market. Then. Last page, then. Issued by the location. The last page is the annexure 10 page 42.
this is pursuant to the letter from the Gauhati police station, page 41. Actual.
So there is already a move. Carry out the demarcation.
That-
But it has not been given effect to the petition. If no, and then we issue notice, making it returnable on 11th of May. In the meantime, you carry out demarcation.
But
Why the petitioner council is not?
okay, today morning, the council mentioned that because the petitioner's council is not available, but his name was not reflected in the cause list. If council who mentioned, so according to your lordship, it is, and
Without his presence, the problem is you won't be able to serve peace.
yeah,
This matter is not. Where is Mr. Image? For sake, what case is this?
But, my father purchased the land. I registered people,
Where?
but mutation was not done.
Where?
But the people of is 14.
And and
So that my father died. He was in possession of the land, leaving the petitioners. Now the petitioners want that name of the petitioners.
who are you?
We are the heirs of father.
What are these agreements for? Agreement for sale and all.
That is not relevant here.
I have been
But, that is the father's land, so we are poor person, some amount of taken place from somebody against that land. It is not relevant here. Now your lordship will come to page 36. The petition for mutation, 36, 37.
When did you file the application for mutation? When did you file the application for mutation? After 1970. Your father died in 1997 and you got his death certificate in the year 2013. Huh? 22. So now you have, so,
I do agree.
but if you want,
There is
get-
delay.
but Mr. Singh, if you want your land to be mutated, it has to be done as per, not by this type of law. You go and apply as per proper. But you cannot get like this.
No, Lord, my only prayer before your lordship is this. That my petition in either or way, it may be dismissed, it may be allowed by the circle itself.
No, they cannot accept it because of the fact that you need to file it under the online.
Online. But on that, or with that observation, one application may be brought. I'll find.
I is the MSC council appearing on behalf of the petition. Behalf of the petitions. So, if the appeals for respondent number 1, so and so appeals for respondent number 2. It is the case of the petitioner that the father of the petitioner had purchased 25 bighas, 2 kathas, 10 acres of land by the registered deed of sale.
That is that case 14 month.
By the registered deed of sale bearing deed number 1539 on 1971. On no, 8/4/1970. In the further case of the petitioner, that the petitioner had submitted an application for mutation after the death of the petitioner's father in the year 1997 by submitting an application on 25/4/2024. And the said application having not been considered, the petitioner had approached this court. Mr. H. Sharma, the learned counsel appearing on behalf of the respondent number 2 and 3 submitted that if the petitioner wishes that his name, petitioner wishes that their names should be mutated, it is the requirement of law that they have to file their application online, which having not been done, the instant application. Having not been done, the petition, the concerned, the respondent number 2 and 3 cannot act upon such application. They've been included in Annex 6 to the petition. Which a mistake, the learned counsel appearing on behalf of the petitioner submits that the petitioner apply by the online mode, taking mutation, taking into account the above. The court therefore, the opinion that no effective relief can be issued in the instant procedure. That's the liberty to the petitioners to apply to the online mode seeking mutation of the land. It's advised.
Respondent number 2, it will be respondent number 3, madam. I have to apply to circle officer. Respondent number,
I'm not saying who. You apply, how will you? You may even give it to Mr. the Revenue Secretary, that is your request. We will again see, we will again find them. I have not mentioned you will file online. It has to be
Subject to correction, I have had that to respondent number two. All right.
Payment of the money. Then, if the date of order release, there is 27 to 2026. Between two parts, one by the deputy commissioner, other by the. So far the deputy commissioner part is concerned, he is requesting the petitioner to come on brief. At the rate of 1,20,000. Then it has been communicated to the petitioner. But probably by the 4 lakh or so, so he has not submitted it. So they.
We do one thing.
Yes, under process, let him submit it, lordship will record it, that areas part or whatever, that amount will remain, madam.
He cannot submit, he cannot submit the bill like this. You do one thing, as regards the non-payment of dues, approach the civil court. Because you see, the moment you submit the bill, you cannot claim more. You want to submit the bill, it's okay. You cannot claim more. They cannot be under protest the bill. It looks very innocuous when he makes the submission under protest the bill. But how can you have a bill under protest? So therefore, you cannot. Now the house is vacated. If you have any claims, go to the civil court.
One thing, Madam that they have assessed,
And you see, if the amount is not paid by them, they will be at liberty to in the meantime tender a certain amount if they wish.
That part divided. Because the proposal has been moved.
So they will be at liberty. You can, if you are not agreeable to what they are offering you, it is for you to move the civil court.
But the only thing, Madam, I have submitted, my note, they have assessed 15 which I have already annexed, Madam. It's my petition, Madam. And I have talked with the petitioner, Madam. He is agreed to that, and my note, that is, my note. 3 lakhs 8,900. On that basis, your lordship has directed to their my note. I have no objection, Madam. I have talked.
Are you agreeable?
That I have already. That is their assessment. Madam.
Give me one thing. You have held that his entitlement is 1,22,848 per month.
Per month.
Okay. Now, why in this letter of 25 to 2026, why it is said a monthly rent of so and so only for the period of
That is for the deputy commissioner. The rest amount by other communication from the SP.
So this is the amount the government is therefore, home and political is therefore moved for release of this 8,77,000.
No, but the other. It has been enhanced to 1,60,000. For the rest of the period by the home department. Till my lord January 23. 120. For the MBA.
So now,
So 2 parts, my lord, by 2 of.
so there are two amounts. One is 54 lakhs and the other is 8,77,000. You are agreeable with this?
No, Madam, I am just pointing out that I have already annexed with their assessment method.
Are you agreeable to this? If you are not agreeable to this, how can I help you? So they are putting at 54 lakhs from them, from 1/4/2023 to 31/1/2026. And what about the earlier period?
Earlier, madam, that, as, the rate of 1,20,000.
Understood, from 26/8/2019 to 31/3.
Fine.
What about the three in the meantime? What about 3 years thereafter? See these two communications,
One is, madam, till 31st March 2020.
2020. After that, what has happened?
It was handed over to the SP.
So why this particular document of the SP only refers from 1/4/2023?
One, 3 years again.
There's a gap.
But madam, these 54 lawsuits is given, fact, it has been, become on the board by the government court. The SP wrote, madam, the SP Kasa on 30th of May 2023. Last paragraph of it. Requested to continue.
Understood. So therefore, prior to that, the BC has to do it. Why
That
this
part
is
is-
not being done? And why you are only asking for this bill from this to this?
That I will take that governor. Based on this level. But they are, but nothing has been disputed regarding this existence, but during that. Whatever they disputed initially.
So
Now they are
therefore,
looking at-
therefore, each document is written by the district development commissioner is only for these 4 months or for 6 months. It does not include the period for 3 years almost.
I understand.
1/4/2020 to 1/31/3/2023. Isn't it?
That is 31st March.
When the matter was being taken up, Mr. P. Gogoi, the learned counsel appearing on behalf of the district administration, Kachar, as well as for the Home and Political Department, Government of Assam, submitted two documents which are kept on record and marked with the letters why they feel to free willing more in to guide me so that the control will not. I should conduct before we go to go. Then I will mark on to 6%. What is wrong with these people? So if they are not in a position to do any XYZ right now. Mark the kept on record and marked with the letter N, Y and Z. From a perusal of the said document, I kept on record and marked with the letter Y here. That there is a move for payment of an amount of rupees 8,77,863 for the period for as the rent for the period from 26/8/2019 to 31/3/2020. Further to that, from the document which is kept on record and marked with the letter Z, it is seen that there is a move for payment of an amount of rupees 54,65,432 to the petitioner for the period from 1/4/2023 to 31/1/2026. However, this court finds it pertinent to take note of that there is no move on the part of the district administration under whose possession The building of the petitioner was during the period from 1/4/2020 to 31/3/2023, which is also an admitted fact and will be apparent from a perusal of Annexure 15 to the petition. Further to that, there is nothing on record to show that there was, further to that, the Home and Political Department of the Government of Assam had vacated the building in question only on 27/2/2025, 26. And there is nothing mentioned as regards the rent payable from 1/2/2026 to 27/2/2026. Mr. B. Gogoi, the learned Additional Advocate General shall obtain necessary instructions in that regard and place the same before this court on the next date. List this matter on 4th of May 2026 for an update.
Not in this case, there was initially an interim order. Despite the interim order, as the arrangement was going on, we filed IA 1557 of 2025, whereby my lord, 2 months' time was given to the respondents. Lordship to kindly come to para 29 of that order, dated 7/8/25, passed in the IA.
Matter pertains to what?
Not actually what's
All
happened.
that condition.
Carriage of food grains from FCI go down to fair price shops. Having interfered with the ad hoc arrangement made by the District Commissioner Tinsukia for transportation of food grains involved by engaging a private contractor.
That clause is per whether he will, whether a private contractor can be
Authorized agency
authorized, whether a private person will come in, because the authorized agency
has
definition
been
is
defined,
either a corporation or.
including a cooperative society. They have interpreted for ongoing is election came the other day, but 60 days time was given from 7/8/25. Please come to that para 29, Milord, which I was reading. Appreciating the said aspect of the matter, this court provides that District Commissioner Tinsukia shall continue with the present arrangement of transportation by private contractor for a further period of 2 months from today. In the meanwhile, District Commissioner Tinsukia shall select an authorized agency for transportation by food grains involved, and the agency so selected shall be one as specified in provisions of paragraph 2G of the order of 2015. Said arrangement would be subject to further orders passed by this court in connected with.
Which order we are referring to?
This is the order in the miss case. IA 1557 of 25. Para 25 of the order. Where the private contract with the private contractor was interfered with, however, having regard to the fact the matter relates to Milord supply of food grain, therefore 2 months' time was given.
So they have in the meantime gave it to some cooperative society.
No, they're still continuing with the old private contractor. That for subsequent to 7/8/25, we have filed an affidavit and take up for affidavit dated 15/11. That order has been compiled.
I remember you say that you have given it to some cooperative society in the meantime. Yes.
That has been compiled. Now, I'm referring to object order dated 17/11/2025.
But there I have duly taken, whereby there was a specific direction upon the responsible stop implementing the Eviction to private contractor and only permit the entities coming under clause 2G of the order to come and carry out the implementation. Upon hearing the it is transpired that it is on the basis of it. The petitioner has challenged the notice primarily related to permitting private contractors to participate in the state notice. This court further takes note of that right and order details where this court has directed the notice that data should not be acted upon, and this interim order continues to be. This court has also taken note of the submission of Mr. Pina that includes the order passed by so. The notice inviting tender had thereafter not been acted. The submission of his questions and inquiry being made by the state authorities are in a position of the notice, there is a notification made to the order. As the issue involved is as to whether a private contractor can be permitted to implement the demand terms which was serving of the union. The opinion of the court that the cooperative society is granted a contract. Nothing would further survive in the instance. This opinion is based upon the submission of the learned council that no cooperative society currently meets the eligibility criteria. Accordingly, this court therefore fixes the matter on swell. In the meantime, liberty given to the respondents to reschedule the tender date so that the eligible tenders can be permitted to participate. The respondent authorities are further given liberty to process the tender. Then upon finalization of the bids, the respondents are given the liberty to bring it to the notice of the court. By having an application in the events of finalization prior to the date. Yes, now what has happened? Why it is not being complete after 1711? How many months does it take?
Election notification came the other day. Before that, what you were doing?
Why? Or you knew that election notification will come immediately? No, how does it take such a long time? Because the election notification came on 15/3. 4 months prior to that, the order this court had directed and accordingly fixed the matter on 23/3. This court also thought that in certain circumstances, you must have done it earlier also. So therefore do it.
They have indicated that some other
Should be observed that to the effect that the state of Assam is not capable of carrying out this. So let the central government do it on its own. It seems so. Understood, 27 or 26, but when this court had granted me 4 months,
that's not what I know.
it shows the total incompetence of these officers. I think these officers should be suspended. Or it is otherwise may have been that these officers have some hand in glove with the new cooperative society who have been engaged. It appears so. Something is wrong because in doing so, you did not invite any tender for doing the interim arrangements after that order.
And subsequently, paragraph 6 of the website that watching on the interim arrangement, you have not given it.
Did you issue a tender for the interim arrangement? No. You have only given to a cooperative society. Because it is the very submission of Mr. T. Devari on the earlier occasion when the matter was taken up that look here, no cooperative society otherwise meets the criteria.
Because of the financial credit. No, it was, but their submission, the petitioners are not, but the petitioners are not. Other.
No. Their submission is also that no cooperative society. Therefore, then my therefore question was, on that day, can you see paragraph 10 of my order of 1711? Under such circumstances, as the issue involved is as to whether a private contractor can be permitted as to implement the so-and-so in terms of so-and-so, it is the opinion of this court that if a cooperative society is granted a contract, nothing would further survive in the instant petition. This opinion is based upon the submission of Mr. T. Devari, the learned counsel, that no cooperative society currently meets the eligibility criteria. Therefore, the challenge, one of the terms of the contract to the effect that you have put it in such a manner, or the words would be, if I import the words, what is going to come out from Mr. Ken Chaudhary, senior counsel's mouth would be tailor-made. Mr. Nath, this is very, this doesn't show the, very. If a tender takes 4 months, can't help it. No, what is there? I have cleared out all hurdles. I've asked you to go ahead. What stops you for last 4 months to carry out the necessary exercise? Tell me. Let us see the face of this additional district commissioner. William, what is the trouble he may say? Because you have been given at the last moment. He is also very clever, not giving you the details. Something wrong with this edition of district commission, otherwise nobody would have done it. When all hurdles which were there in this petition, I have cleared it and say, go ahead, look into it. And I've given you 4 months. And 4 months you cannot then, there's something wrong. Mr. Dina, the learned senior government advocate, submits that he does not have the proper investing instructions as to why the respondent authorities have not been able to finalize the tender, finalize the notice inviting tender dated 26/3/2025, in spite of the fact that this court granted 4 months to do so. It is very pertinent to observe that in pursuance to the order dated 7/8/2025, passed in IA Civil 1557/2025, the respondent authorities have picked and choose a cooperative society for implementation of the, to carry out the implementation of the Food Security Act 2013. The delay in finalization of the contender, in spite of the clear directions passed by this court on 17/11/2025, does not appear to be in good taste. Taking into account that Mr. D. Nath, the learned senior government advocate, seeks for some time, lists this matter again on 2nd of April 2026. Mr. D. Nath, the learned senior government advocate, shall provide the necessary instructions as to why the tender could not be finalized. Right? Roman. If you promise that you are going to finalize by then, because this direction is model code of conduct would not affect, then the issue block them back. Even undertaking. So let's have it on Thursday and hear what is there, and then again on Monday, if we see.
How about Rajeshwar Sharma, who is representing Union of India and Railway? But he is out of station for his own case at Kardianala. If possible, kindly adjourn the matter for 2 weeks.
Humble request before the phone. Yes, Mr. This case was active. One, one. But this is not a case of demarcation, Mr. Counsel. Here? No. Mr. Nath, this is not a case of demarcation. It is a case where they have initiated the process under the unauthorized occupants of public premises. Now, after passing of the order under section 5, no steps are being taken by you. You see, they cannot do it by themselves. You have to help them. So you need to help them. Why you have not done it? That is the only simple question. Kindly see the annexure. Deputation of magistrate along with local police. Kindly see 21/2/2012, 3/2012. These are being directed estate officers' orders that have been given out there. Why you are not taking help? Three. Yes. Understood. That is a different aspect which you have just shown it to me. This is a case of demarcation. We are not on that. Here, an authority have been given a power under the Public Premises Act to act in terms with the orders passed. Now, they on their own cannot do anything. They cannot carry out eviction. If you want the railway police to come in, they will help you, they will do it. But railway police cannot enter into this aspect of the matter. It is the state. The state has the power to do it. So the state has been asked to do the needful. Yes, sir, the acquired land and within the acquired land, addition, they are awesome. In the other petition, yes, sir, the private component is required being constructed. In that premises, both the matters and directly of district of the region of the to see that particular land that they are claiming, it is the acquired land or not. So on 27th floor, officer, so nothing. Kindly come to annex page 17. A plot of land of the railway measuring 40 by so and so near Polasbari so and so is under unauthorized occupation of Sri Ratul Dekar since 2011 and construction is going on. The estate officer had authorized the senior so and so to take possession of the land by evicting the encroachers in so and so. So the date of eviction is fixed on so and so, and in this connection, your assistance is required. So to depute a magistrate for doing that against Ratul Dekar. Okay. Then again you see same thing in Annex 4. Then Rakul Deka writes to the divisional engineer, I have the honor to inform you that I am Rakul Deka, contractor of so-and-so and have been working by the work order under the NRHM government of Assam and the following. That sir, I will stop the work for the day itself till finalize the land matters by so-and-so. Then mission director has been written to the effect. As the construction work is not being stopped, the estate holder has given authority of conducting forceful eviction. Now my question is, there a power has been conferred under the Public Premises Act. If that power has been exercised not properly, that power has to be, the order of eviction has to be challenged under Section 10. That having not been done, the state is not providing, because a machinery of the state is in occupation or doing whatever of the way. So therefore, the question is, are you not bound in terms with Article 256 of the Constitution to abide by all the laws made by the Parliament? My question is simple. Let the state government say that we adopt the Constitution, we adopt the Parliament. Then on why on earth you are not doing it? Yes, NHRM or NRM, whatever may be, they can challenge under Section 11. But there is a process which is will be given. Or is it the fact that when the state government encroaches upon the land of the railway, the railways have no other way? You cannot raise all these things. What is he asking for? Kindly provide, kindly look into this. Obligation of the states of and the union. Executive power of every state shall be so exercised as to ensure compliance with the laws made by the parliament. But are you saying that the state government is not going to abide by 256? Then this is the simple thing which has been sought for. That's true. It is one of the state of the finance. I'm not clear about. So therefore, if there's a dispute, challenge it. Challenge the dispute before any court. State administration are very difficult to see. But we are court cases. The other part is Section 4 of the Public Premises Act says you issue a notice to him. Notice has been issued against Rakul. Then, thereupon, the Rakul say, then Section 5 order is being passed, rightly or wrongly. I'm not saying that whether the order is right or wrong. Now, for that, are you not required to challenge the order under Section 5? NAHR. Now, who are you to say that I am not going to abide by the order? Because that is the law made by the parliament. So therefore, you are required to violation of Constitution. But that's what Madam may very well say, look here, that is violent. But she has to challenge it by way of it to be done, or challenge it under Section 10. But when there is an order by this railway, you have to comply because you are on a different footing. You're the state, you're the executive power of the state. I'm not on the question of demarcation. I'm on the question of you are to comply. Whether she files or not, that is her look. But you are to comply because that is the law. Otherwise, the rule of law will go for a toss. What do you have to say, madam? You are a party. No, that is not the question. You are not challenging that order. An order has been passed against the estate officer by the estate officer, saying that you are in a wrongful possession. The order was passed against Ratul Dekar. Ratul Dekar was working on the basis of a work order issued by you. So therefore, the question is, why are you not challenging that order? For given undertaking, you will vacate it, he will be happy. Given undertaking. How much is the land? Forty by 30 meters will be around 1,200 square meters. 1,200 square meters will be more than around less than a katha, bigger, less than a katha. Katha would be 2,880 square feet. Oh, so this will be 1,200 square meters will be something around 1 bigger. So this land is in the area. So in the present petition has been filed challenging the inaction on the part of the state respondents in providing help for eviction, towards the eviction of the respondents who the estate officer in its order dated 15/3/2012 holds that the concerned respondent are in illegal occupation of the land belonging to the railways. The learned counsel, the learned senior government advocate submits that there are certain disputes. However, it is the mandate of Section 4 and Section 5 of the Public Premises Eviction of Unauthorized Occupants Act 1971 that a person in unauthorized occupation of the public premises can be evicted as per the mandate of the said Act of 1971. This court also takes note of Article 256 of the Constitution, which stipulates that the executive of the state, as well as the union, are obligated under law to ensure compliance with the laws made by the parliament. The Act of 1971 is an act made by the parliament. Under such circumstances, Mr. Dina, the learned senior government advocate, shall apprise this court on the next day as to why effective steps have been not taken for compliance with the requests so made by the railway authorities. List this matter again on 4th of May 2026. Madam, I have fixed it on court. In the meantime, you take steps by filing a writ petition or something. Yes, who is there? 2014 matter. Mr. Mohanta, such an old matter, why?
My lord, because of the, my lord, pollution control board, my lord, feed and all, my lord, because my lord, once a stone crusher machine situated in the, my lord, the cell area. And then, my lord, cell area, then, my lord, it was on a plane, my lord, it was closed down. And thereafter, my lord, again it was open. So, your lordship kindly see, my lord, page 26, your lordship kindly see. Page 26.
Yes.
Page 26, my lord.
This is where? Sibsagar.
Itabar.
Page 26 is a complaint.
My lord. Then your lordship kindly, after that, my lord, your lordship go to the, my lord, page 36, my lord.
But can we have a stone crusher unit within the residential area?
Yes, my lord, that is the, and also, my lord, the health hazard, my lord, that is, my lord, pollution control board himself, that themselves stated that is a health hazard, my lord. But even then, my lord, on the basis of the inquiry made by another authority, they again allowed to, my lord, continue. So I'll.
Yes, pollution control board. And who is paying for the private respondent? Yes, you are having it in the residential area.
Let the DC.
Okay, this matter came up once before me. No. There is another place. No, you see, you have now been made an industry. The industrial area is only for the purpose of collection of revenue. This is done under the Assam Land Assessment and Reassessment. But the question is, the resident, if it is a residential area, it continues to be a residential area, whether it impacts upon these people. What is your stand? Not prepared. No, man.
Thing is that this initially it was functioning and we don't have the authority to give the license, it is the forest department. The Stone Crusher Act has it.
I'm not on that. No, no, Mr. Counsel. Forest Department will look into as to whether stone crusher is permissible or not. That is another thing. But the pollution has to be yours.
Permit has
There are two aspects. One is a consent to operate has to be given by you. Have you given?
Yes, we have given.
Then, as per you, there is no pollution. So,
We have given time reports and those are part of my affidavit of
so there is no pollution.
functioning for years together. And till 2025-26, they have been given the fresh.
So, what is wrong then, Mr. Monto?
Your lordship kindly see page 36, my lord.
Okay.
36. Page 36 might be 15.
So at that time, the member secretary thought something else.
Because initially they were complained and that point of time in 2014, there was no provision for public hearing. Now, normally this kind of industry, when it is established, we go for a public hearing. And that public hearing will be carried out in the presence of officials of the board and also the district administration. So when the complaint came, we have asked for a extra conscious, we have asked the authorities to go for a public hearing. And that public hearing has come in and the ADC has given a report to that effect that, okay, the residents who are residing at the port close proximity, in fact, at a distance which is normally permissible. So they have no objection as regards the establishment of it. So that was the condition. And accordingly, the withdrawal, there was initially a suspension of the order of consent. It was withdrawn and finally they have agreed and they are coming for the court.
And from time to time, they are giving the authorization fees and also the inspection, we have been doing it. That's it. And so there is no violation as such from our side. Where do you stay?
My lord, you want to can see their affidavit here?
No, no, and I'm seeing from page 53 of your petition. And where do you stay? Page 53 of the,
And,
eh?
and within 50 meters of the my lord, that location.
Page 53. Where is your house?
Not sure. CL number 10, my lord. Look, not shaky.
Ah, they are farther down the road.
No, my lord. They are already, the inquiry report, they have submitted that within the proximity, my lord, within 15 meters, they are actually filed by the deputy commissioner, he is also there, my lord.
So nowadays, you can very well get the pollution there. Without them also, you can get it. Show some evidence to this court that there are some pollution going on.
My lord, your lordship kindly see the affidavit filed by the pollution control themselves stated, man.
Where? Filed with the respondent number 6 on 13th of March 2015.
Another affidavit that is filed on my 23. There are 4.
2006, 16.
They are page, my lord, 166, start from page 160. There are 4, my lord. Oh, this is held by 6, 7, 8, 9. Pollution control.
Now, where is he getting the stone? Forest? No forest. Consent to open it for the union. And what is their latest affidavit?
Because in that affidavit, my lord, they have clearly stated that there is the sound pollution which is created to the my lord, that is beyond the permissible limit. In paragraph 4, my lord, page 168.
And government, what do you government, what do you say about clause 2.1? Now, what do you say about 2.1
It
of the
says that-
Assam Stone Crushers Establishment and Regulation Rules 2013?
raised by my lord is whether that belongs to a residential, it's a residential.
That I've seen it from the offer, from the affidavit filed by the circle officer. That I've seen it. I'm on another aspect. Kindly come to running page 237. 37. That is the document, it is the affidavit filed by the respondent number 10. 1. Wherein he has include no something, no, kindly come to the Assam, this Assam stone crusher. Anybody has it? Yes, a stone crusher shall be established at least 300 meters away from residential area, having a minimum population of 100 to 150 people or 20 houses, including both kacha and thatch, and paka houses, and 500 meters from the residential area, so and so. So, is there any compliance to 2I and 2I? It has been notified. Yes, Assam Gazette number 393, published on 17/9/2013.
Because they query the permanent applicant might not, they are asked to might not produce their evidence, but they fail to produce it. And because.
So therefore, as per whether it meets 2.1 and 2.5. 2.5. As per the pollution, it is okay.
No, my
Pollution
lord,
says
that,
everything is
that point of time, they have filed an
No,
affidavit.
that is okay, but by the time now they improved. Mr. Endas, who appears on behalf of the state respondents, more particularly the district administration, Gauhati, shall apprise this court as to whether the stone crusher unit belonging to the respondent number 10,
Not every success.
the respondent number 10, bracket 1, to the private stone crusher unit belonging to the private respondent complies with the mandate of Rule 2.1, Roman 1, and Rule 2.5, Roman 5 of the Assam Stone Crusher Establishment and Regulation Rules 2013. To submit this matter on 6th of May 2026. An affidavit in that regard be filed by the circle officer. It's about revenue cycle, na? On the next day. On the before next. Yes.
My lord, the state administration has filed an affidavit on 9th of March, my lord, where they have taken a stand that some of the structures which we pointed out that they have been demolished. They have filed an affidavit, but we have materials to show, my lord, that there are still, many are still operating. We have got the photographs taken yesterday also. Would like to file a short affidavit. But in any case, my lord, these are the, entities who never had any permission. At least as far as we are concerned, we have a permission. And that cancellation of that agreement was also interfered by this honorable court. In that view of the matter, my lord,
No, cancellation is the matter which is subject.
MOU.
Initial, if I remember, initially, they stopped you.
From
And
entering.
therefore, the matter went before, Justice Mehdi. Justice Mehdi specified those order.
Yes.
And however, mentioned that the interim order shall, is made absolute.
Yes.
Resulting
Then we sought a
when I was taking up, I asked him for a clarification.
And that
He
was
got the
clarified.
Clarification that it is no longer there. meaning
Everything
that
is-
I can very well go inside. That is one. The second aspect pertains to whether, if I'm not wrong, clause 9 was there.
Yes, of the
Clause 9 could have been first taken into consideration in this case when there is no, there was a particular requirement of law.
yes.
Clause 9. That if the running of the camp becomes unviable,
Yes.
the Department of Forest or the petitioner would be at liberty to terminate the understanding by giving 3 months notice. Whether that condition procedure has been,
That was not.
now they come up with additional reasons. So additional reasons.
While
you have
addressing
given
the
also-
additional ground, while the matter drags on for almost a year.
Similar issues, my lord. This area falls under core area.
No, well, that's a very wrong statement.
Maybe buffer.
It is in a
also,
buffer
but-
zone.
I. Yes. So.
It's a
there's
buffer
judgment,
zone.
my lord. To Corbett Tiger Reserve. Very. let's put it in, that every activity relating to whatever they want to do has to be as per the guidelines of NCTA. NCTA guidelines is in the books, my lords. It
Okay, you are permitting
my lords, and that apart, my lords,
mining operation in the Aravali Hill. And you are.
I am not, I need to answer it.
And what else?
NCTA guidelines, I am not, in the book, lords will find. It takes care of the community that, it takes care of whether the community should be involved. by it. And regarding the activity, my lord, they are, initially they came and they were protectors of fish, that machine, golden machine, they want to research on them. Further, they expanded.
Come to page 63 of the book.
PCP is that. PCP, one, Tiger Conservation Plan. It has been approved, my lord. We have filed a recently.
Please come to 47.2.3, Roman 3.
47.
47.2.3, just Roman 3. Eco-friendly tourism facility and infrastructure can be allowed
Yes,
in
yes, yes.
non-forest land in
No
local area of Tiger.
No point. Now let's come to basic system.
Yes.
Here is NCTA guidelines on tourism.
The direct all states must adhere to the NCTA guidelines for tourism and thus adopting the overarching aim for regulation to move towards a system of community-based tourism around Tiger Reserve.
Right.
The restriction against night tourism and it also gives that. So
So, Madam, guidelines, what you will take it.
notifying the buffer area is imperative for Tiger land reserves to be operated in the landscape and to effectively implement the landscape around the entrance. All states are hereby directed to notify the buffer and core area of the Tiger reserve within 6 months from the date of the judgment. Now, have you notified?
Yes, my lord, we get to, lots of us take the quite, this act, my act itself contains, when you have, there's a guidelines when.
No, I'm saying, we are 6 months yet to happen. Have you notified?
Yes, ma'am, we are not,
Notify the buffer and the core area of the Tiger reserve.
my lord, yes, ma'am. Lordship will give, lordship take note of book, my lord, in the year 99 2000, my lord, we are not. Page 298. New book, my lord. These are the guidelines of 2020.
Is the core and critical tiger habitats such as we are concerned with?
buffer, my lord, Lordship will see another, there's another page, my lord, it's annexure B. In my
Appendix E.
appendix B,
We are concerned with which place is this?
Namedi, my lord. 20, sir, not, if I'm correct, my lord, it's serial 27.
Ameri Assam. What is that area of buffer?
Yes.
Is 144 square kilometers. Now the question is whether the petitioner falls in buffer or core.
And our interpretation is in 4.
I'm asking you.
My instructions are clear, it's 4. My instructions say it's 4. Because I cannot go out of the impugn order, my lord. Seriously.
Core would be 200 square kilometers. Square kilometers.
Right.
Appendix A.
Seriously.
So now in core,
Get the impugn order, my lord, at page 191.
I'm not on that. In core, is it permissible for carrying out any action?
Nothing is coming.
Huh?
Nothing is coming.
In core?
Yes.
You paying the any statutory or regulatory payment as per the judgment of the Supreme Court?
My lord, that PCP, Lord, conservation bill is ready. That has been approved by the National Conservation for Tiger.
Have you done it?
Yes, yes, not very. There's no affidavit there. I annexed them.
When did you do it?
It's no affidavit from the state. Taking its time. The PCP has been.
Where is it mentioned that in court it is not permissible to do anything?
What's your goal? Page. Certain. Can I say? Either as a national package.
Core area has the legal status of the national park only. So where is it mentioned that within core nothing can be done?
If I don't so if you assume character of national park. And come.
Yeah.
Wildlife protection.
So what is permissible is A to B. A to B of section 33.
And these are permissible.
These are permissible.
And also the issue for a buffer has been covered under section 38B.
38B. 38B. Then subsection 4, which explains what is, how 4 has to be dealt with, how buffer has to be dealt with. 38B, packet B for the. Then is done. Section 4 is the, sub 4 is there, is, there are two subs.
So explanation are required to be kept as violate for the purpose of tiger conservation without affecting the rights of the scheduled tribes or any other forest dwellers and notified as such by the state government in consultation with the So the issue is, in a case of four, then he cannot, no, even.
Yes. If it is a core, I cannot.
If it is
Buffer,
buffer,
he has to stick to guideline. Now,
My landed is making unnecessary.
Mr. Gogoi, listen to this. Kindly see 47.2.3 human eco-friendly cruising facility and infrastructure can be allowed on forest land area.
Kindly have page 76 of the writ petition, minor, just to show the location of the camp. Page 76.
Yes.
Kindly see, my lord, Nameri range office towards the bottom on the left hand side. That's the range office. And next is the eco camp. And this is Balipara Forest Reserve Western Buffer. Is a forest department's map. When they are guided by ruling party MLA, my lord, they will naturally come up with all these statements. Protect whom all these things will be done. Too fast, too far.
Nameri, and which one are you saying to?
Now, kindly see Nameri range office, just near to that is the eco camp. It is in the buffer zone, my lord.
Outside.
Yes.
Nameri.
Just, my lord, that's the entrance. And my lord, kindly see Potasili village is inside, in the inside, just in the core part. my
Okay.
lord.
Now we do one thing.
Yes.
the lordship will kindly.
No,
reduce
Mr. Gogoi.
Paragraph 48.
No, Mr. Gogoi. You file an affidavit that as per their contemporary reports, that they are a quorums.
My
You file a-
yes.
Once that is done, in its,
Yes. My lord will kindly fix a date after the meeting. Lordship will dispose of
you
it.
just file an affidavit that it is also within the core area. That
Lordship,
and also mention what is this document? Annexure D.
Annexure D is the map filler of the Nameri National Park.
This map is made by whom?
Forest Department, Government of Assam.
Heard Mr. Kane Chaudhary, the learned senior counsel, if you can, to G. Rahul, appearing on behalf of the B. Gogoi appears on behalf of the Forest Department of the Government of Assam. The issue involved in the present proceeding boils down to the issue as to whether the location of the petition of the Nameri ecocamp is within the core area or the buffer area of the Nameri Reserve Forest, National Park and Tiger Reserve. Mr. Ken Chaudhary, the learned senior counsel, drawing the attention to Annexure D to the Requisition and more particularly at page 76, which is the map, which is the visitor's route map prepared by the Forest Department of the Government of Assam, submits that the ecocamp is situated in the buffer area and not in the core area. On the other hand, Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department, referring to Appendix A and Appendix B of the Wildlife Protection Act 1972, submits that the ecocamp is situated within the core area, wherein there can be no establishment of any other within the core area. And that area has to be treated as a sanctuary in terms with section 33. Of the Act of 1972, read with section 38B of the said Act. Taking into account the said aspect, this court directs the PCCF to bring on record by filing an affidavit as to whether the ecocamp, in respect to which there was a memorandum of agreement with the petitioner, lies within the core area or the buffer area of the Nameri
Reserve Forest. Palipara, my lord.
Nameri National Park and Tiger Reserve. List the matter on 7th of May 2026. The affidavit be filed on or before 4th of May.
So that week, my lord, that CA matters are fixed by the Supreme Court, that Constitution, that CA matters, my lord. So it will be on Monday, my lord. 7th of May, my lord, matter will continue.
On 12th of May?
Yes.
On 12th of May, let them file the affidavit by 4th. And the petitioner would be at liberty to file in reply.
Exactly.
Speaking near kind of makes no personal. It's not even, I will
Which?
My lord,
Some
so many
MLAs say,
things,
I
my
don't
lord,
know, I
my
don't know.
learned friend is a pawn, he doesn't know what is happening. My lord, one person. my lord,
Mr. Sodri, you may say anything to anybody, but don't refer your learned counsel as a pawn.
Anyway, do it go.
Give me a report. The petitioner is a landholder of 15 lessers only. There has been a report of that mandal in the demarcation case.
With petition. Other than
The so appearing on behalf of the BTC submits that copy of the be served upon her so that she may be able to obtain necessary instructions. Mr. B.J. Mukherjee, the learned counsel appearing on behalf of the petitioner, shall provide a copy of the petition to Ms. Lorenzo during the course of the day. List this matter on 13th of May 2026. In the meantime, the BTC shall apprise the court as to why the demarcation process of the plot of land of the concerned plot of land have not been carried out till date.
file additional authorization. File the instruction minus and this thing minus
Okay. Who is to file the affidavit?
I received from the commissioner. Who can be granted time and
Provide a bodyguard to him. No,
but if
he's asking for renewal of his license
but
out of fear, out of apprehension. He categorically said that the requisites of section 17(3) is not met of the Arms Act. So therefore, the question is, you provide a bodyguard to him.
it's up to the lordship will pass order manner that will take on.
This court specifically directed the respondent number 4 to file an additional affidavit as to whether any of the conditions mentioned in section 17(3) of the Arms Act of 1959 exist for revoking the license of the petitioner. However, no additional affidavit has been filed, but rather time has been sought for another 2 weeks. This court fixes this matter again on 28/9/2026. In the meantime, the affidavit be filed on or before 27th of April 2026. It is observed that in the circumstance no affidavit has been filed, this court shall construe that there exists no reason, there is no satisfaction to the conditions as mentioned in section 17(3) of the Act of 1959 while passing the impugned orders.
May it pleases your lordship, lordship, this is in connection with cancellation of the self permissions issued by the office of the District Commissioner, Kamrup Metro at Gauhati. The respondent side was to file an affidavit as reflection of the past order.
Your file?
No, lord.
Lordship, we have been directed to obtain instructions regarding this letter as because, may I place this letter?
No. Because of the fact that this letter was placed before this
Yes,
court on 11(3),
I got the.
and I say that kindly receive instruction but could not file the affidavit due to paucity of time, and therefore I fixed the matter today. So you don't file it.
Lordship, today morning I received the instructions that no, we have not yet received any date from the Director of Survey.
So therefore, we construe that there is nothing out there. There's no instructions from you. What do you want the setting aside? We set aside those.
Lordship, we are praying for allowing us to get our sale deed executed on the basis of the sale permission that has already been granted by the office of the District Commissioner, Kamrup Metro, after the proper verification. But those were cancelled. As a circle officer, he issued a letter by which he said that the land requires re-verification. And on that ground only, all the sale permissions were cancelled. Kindly come to page number 68. When we went to apply,
We pass an order that we cancel this revocation and allow the petitioners on the basis of the earlier year and to register if otherwise the other terms and conditions of the Registration Act is followed.
3. And after,
What does that joint verification has anything to do with his right to hear? Why do you have this NOC? NOC is for the purpose. There are for security reasons you are exercising the power and also to verify as to whether that person who is executing has the right or not. So you have given it. You have then revoked it on your own without giving him a notice. So therefore, we set aside this revocation, allow him to go ahead and do it. This type of things is not. Oh, you have now become means whatever you cannot extend section 21A right to do whatever you feel like.
At that section 21A does not provide for cancellation of already given NOC.
Yeah, that is not there.
They can reject my application, but once it is given, they cannot later on cancel it. And they have not even passed a speaking order. And
Where is the cancellation?
the cancellation is reflected from page number 68. It was shown in NGDRS like this. No speaking order was passed. When we went for our registration in the NGDRS, emphasis NOC was cancelled at page 68. And when we inquired, we came to know that of the basis of the letter, which is at page number 69, issued by the circle officer to the co-district commissioner, his permissions were cancelled. And this letter is also later on, because we were issued NOC on 28/3.
And what is this, Mr. Sharma? Paragraph 8 of your affidavit. Government DAG number 5372 is different from the DAG which is in possession. You have cancelled it on the ground that the boundary, the north-south, east-west boundary is different. That's all. You should have sought for a clarification. You cannot do
That
this.
is why letter was issued to the director of survey, Assam.
No, are you going to see the schedule of the land? It is between him and him. Somebody is selling to somebody. If the schedule is wrong, that is for them to look into it. Are you certifying it nowadays? My question is, Mr. Sharma, are you certifying any sale deed? You are registering a sale.
Lakshmi, I will just add to one thing. Here it is written after field verification, the government DAC number 5372 is different from the DAC which is in possession. Now, our land in dispute is 5373 DAC. So it is totally different land.
Understood. You see this. Kindly come to page 52 where you get the answer why they have done it.
Page 50.
52. See the schedule. 5373.
5373.
Then
North
north,
5260.
DAG number, south is,
5372.
this is the government DAG.
This is a government.
So they say that this area, the schedule appears to be something wrong. For that, they are doing it. And they have given the opportunity, they have not done it. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Petitioners. Mr. H. Sharma appears on behalf, Ms. N. Bodlo appears on behalf of the respondent number 1. Mr. H. Sharma appears on behalf of the respondent numbers 2 to 6. Huh? appears for response number one, appears for response number 2, 4, 5, and 6, and Mr. So appears for response number 3. The petitioner number 1 is the owner of a plot of land at measuring 3 acres 17 letters covered by tag number 6519 old oblique 5373 new, comprised of KP Patta number 19 old 81 oblique 811 new, situated at Revenue Village, Sohor Potasil under Moza Beltola, under the within Moza Beltola under Dispu Revenue Circle in the district of Kamrup Metro, Assam. The said land have been more specifically described in Schedule A to the petition. The petitioner number 1, on account of necessity for money, executed 6 numbers of agreement for sale in favor of the petitioner numbers 2 to 7. And thereupon applied for necessary sale permission before the office of the district commissioner, Kamrup Metro at Gauhati. The sale permissions were granted to the petitioner, which have been enclosed as Annexure B, Annexure 2 series to the petition on various dates. That is on 19/3/2025, and that is on when?
28/3/25.
On 28/6/2025.
28/3/2025.
28/3/2025.
And these are annexes 3, 4, 5 on 6. And
And the various sale
8.
permissions have been granted to the petitioner on 28/3/2025, which is Annexure
annexure 3 to 8.
Annexure 3, Roman 3 to Roman 8. The petitioner thereupon sought for permissions from the respondent number 3. And such permission was also granted, as would be evident from Annexure 9, Roman 9, 10, 11, 12, and 13.
30.
The petitioner thereupon paid the stamp duty for the purpose of registration of the sale deeds by purchasing the e-stamp. And on 28/5/2025, the petitioner applied for registration of the sale deeds through the National Generic Document Registration System portal. To the shock and surprise of the petitioner came to learn that all the sale permissions which have been granted were cancelled, was shown as cancelled in the nzbrs.assam.gov.in portal. The petitioner further visited on 5/6/2025 to the office of the district commissioner, Kamrup Metro, seeking information as to why the sale permissions have been cancelled. That too behind the back of the petitioners. Upon verification, the petitioner could come to learn about a letter written by the circle officer, Dispur Revenue Circle, to the senior sub-register, Kamrup Metro, on 30/4/2025. Wherein it was mentioned that the land involved in the sale permissions required re-verification. The petitioner thereupon submitted a representation on 6/6/2025 to the District Commissioner, Kamrup Metro, for upholding the sale permissions issued and thereby permitting the petitioners to go ahead with the sale transaction. The same having been denied, the petitioners have approached this court by filing the instant petition on 11/8/2025. The record reveals that on 18/8/2025, this court issued notice no affidavits were filed by the respondents till 8/December/2025, wherein the circular officer of the Dispur Revenue Circle mentions at paragraph number 8 that it was found during field verification that the government DAG number 5372 is different from the DAG which is in possession. It is notable to take note of that from the very sale permissions which have been sought for, where in respect to DAG number 5373 of KP Patra number 811, and in the schedule to the said sale permissions, the DAG which have been referred to by the circle officer in the affidavit, that is DAG number 5372, is shown in on the south. Question arises as to whether the respondent authorities could have taken such action of cancellation of the sale permissions at their own whims, ex parte, on the ground that the boundary on the south refers to a government DAG. This court further finds it relevant that on 11/3/2026, when the matter was taken up, it was mentioned before this court that the sale commissions were not cancelled, but rather it was kept under abeyance. Kept in abeyance. And certain instructions have been received, which the state government government council wanted to bring on record by filing an affidavit. Taking into account the said prayer, this court permitted 2 weeks' time for filing the affidavit on or before 30 to file an affidavit, and accordingly, the instant writ petition was directed to be listed on 33 today. No affidavit, however, was filed. In the backdrop of the above, it is relevant to take note of Section 21A of the Registration Act 1908, insofar as the same is applicable to the state of Assam. From a perusal of the said provision, there is a direction. It is the mandate that without the issuance of the no objection certificate, the sub-registrar shall not carry out any registration. It is also the mandate that within a period of within 1 month, the said application seeking no objection certificate is required to be disposed of. Is be disposed of. The learned counsel appearing on behalf of the petitioner, though submits that in terms with section 21A, the power is there for issuance of the no objection, but there is no power for cancellation. Once granted. However, this court is of the opinion that the state submission may not be in accordance with law, taking into account the provisions of the General Clauses Act, more particularly Section 20. Section 20, which stipulates that when an authority has the power to issue, this authority also has the power to cancel. Be that as it may, it is very pertinent to take note of. The petitioners in the instant case have been issued the no objection certificate, public the sale permissions. And there is no reasons assigned as to why the petitioners cannot go ahead with the execution of the deeds of sale. The only reason which is apparent, which is available at paragraph number 8 of the writ petition, affidavit in opposition, is in respect to a DAG, government DAG number 5372, which has no relevance to the land which the petitioner proposes to sell. Apart from that, it is also apparent that after issuance of the no objection certificate, the respondent authorities at their own whims rejected, did not permit the petitioner to go ahead with the registration. Which is not in conformity with the settled provisions of law. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. taking into account that the petitioners have the sale permissions issued, which are enclosed as annexure Roman 2 to
Roman 3 to 8.
Roman 2 to
Roman 3 to 8.
annexure Roman 3 to Roman 8. As well as the permission from the respondent number 3, which is that annexure Roman 9 to Roman 13.
13.
The respondent number 4. Number 4. Respondent number 5 is directed to permit the petitioners to go execute the deeds of sale. The petitioners, upon execution of the deed of sale, respondent number 5 is directed. So and so and so and so. The petitioners herein would be at liberty to execute the deeds of sale. And upon execution of the same, the respondent number 5 shall register the sale deeds, provided the provisions of by following the provisions of the Registration Act 1908, number 2. The respondent number 5 further is directed to accept the sale permissions which have been issued to the petitioner. By the respondent number 2 or 3. By the respondent number 2. As well as by the respondent number 3. As valid sale permissions and to carry out the registration as directed above.
Deeply obliged.
That is.
Yes, what is your instruction?
Instruction.
The acknowledgement of has already been forwarded to the nodal officer and joint secretary, revenue and disaster management.
Then they have to. Today, when the matter was taken up, the instruction has been placed before this court that the online application for file is presently lying with the special branch and awaiting the submission of report to the nodal officer. It is also seen that the application was sent to the special branch by the nodal officer on 21/12/2025. It appears from a manner in which the respondents are taking actions for deciding an application seeking to violate the year. I fix it after 1 month only for the purpose to see as to whether you comply with this direction or nothing. We have the presence of this officer. Which is this officer? Let's see the face of the room. the district commissioner, Sri Bhumi. Madam, this I've looked into. This is not done. There is a direction passed by this court on 27/2. This court, by an order dated 27/2/2026, directed the respondent authorities to provide an update as regards the status of the petitioner's application seeking NOC. It has been submitted by Miss N. Botlow, the learned standing counsel, appearing on behalf of the Revenue and Disaster Management Department, as well as Mr. H. Sharma, appearing on behalf of the district administration, that no instructions have been provided by the authorities in spite of the order passed by this court on 27/2/2026. It appears, therefore, that these officers, the respondent officials, are not keen in providing the instructions to the councils, or in other words, take the assistance of the councils for their representation before the court. Accordingly, the court directs the principal secretary to the Department of Revenue and Disaster Management Department to be present before the court on 8th of April 2026 at 10:30 a.m. So Ms. So-and-so shall provide the necessary instructions in the, provide the video conferencing link in that regard.
Yes.
We direct the additional secretary, here's written, additional secretary to the Government of Revenue and Disaster Management to be present. Yes, what is this?
Actually, this is for dissolution of the board of directors of a cooperative society. The government has filed their affidavit this morning. But I also want to go through it. This morning they have filed it.
It has been submitted to the government. The corporation department has filed an affidavit in opposition today. However, the same is not on record. The counsel appearing on behalf of the petitioner submits that the petitioner be given an opportunity to file a reply. This matter again on 8th of May 2026. In the meantime, the affidavit in reply be filed on or before 5th of May 2026. Interim order passed earlier. What is the interim order?
No election still disposal of the election.
Why?
Because no election because the board has been dissolved. So I being the petitioners, they are who are the earlier board members, I become disqualified to appear to contest in the next elections. Now the main object in the writ petition is whether the impugned order is right or wrong. If it is wrong, then I become eligible to contest in the next whichever election is comes. So that's why this interim order is still disposal of this writ petition. Elections need not be held. One man committee is running the.
Where is it given till disposal?
My lord, first order, my lord.
No. In the next returnable date.
But returnable, till returnable.
Then what disposal means?
My prayer is that till for next date, interim may be extended.
Okay, we file your affidavit by
5th.
8th. 8th April. 8th April. 8th April. We are not concerned with that. We are only concerned with him. He has made you a party to delay the
They have,
We do one thing, ask him to file the affidavit, reply. You got a copy. We have it on
20th April.
20th of April. 20, affidavit be filed, affidavit in reply, 21st, affidavit in reply be filed on or before 20. Interim order passed earlier shall continue till the next day.
One small, can be on 22nd April. I won't be in, I will reach Gauhati on 20th night.
Very well, you are appearing on 21st.
21st is,
You file your affidavit before 13/10. We'll hear everything next.
Lordship, I'm waiting for some more time to file.
What is the matter about?
Regarding derecognition of
No, your lordship, we have put to challenge your lordship, the accusation proceeding. Therefore, your lordship has asked the government to file their affidavit by
updated-
23rd of March.
some updated.
Requisition.
Acquisition, we have put to challenge.
It's a case of requisition.
Requisition.
They have not gone for acquisition.
Lordship 1964 Act, and we are saying that this, for that particular purpose, 1964 Act cannot be invoked.
A good point. Very important. I think this is a case which requires. response because of the fact that the misuse of the fair right of representation is being taken. And why? Where is the one of these documents? We should, is there a state?
No, there is no stay. Your
I
Lordship.
think we should state. Where is the document? Let us state. it.
Lordship.
Where is the requisition?
Lordship.
This has been issued in 2025. We are in 2026.
Lordship. Page 30, your Lordship.
Page 30. No, we need to set aside this. Let us set aside today itself. No, we set aside. You see, when it is done for permanent purpose,
Lordship.
the law is very clear. It's the Bora.
Lordship.
The Supreme Court judgment is the Bora, which categorically say you cannot, when you are doing it for permanent, you cannot go for reputation. It's a colorable exercise of power. You set aside.
Lordship tomorrow. Tomorrow, Lordship, as because senior government advocate, he is appearing, he is requesting me that some updated instruction, he is going to file an affidavit. So let it be tomorrow, Lordship. Let him
You
appear.
have not filed the
so that-
affidavit. I think you get that judgment and
Lord.
2, 3 judgments also there. And there is one very nice judgment of Justice Ravindra Bhattans. After HD Bora judgment. In fact, I dealt with this case in a matter pertaining to, in the case of near, that place, Adabari. Near Adabari, there was a plot of land which was requisition. And they continue to have it requisition. I think this is a colorable exercise. I think we should stay immediately. I will set aside.
Tomorrow, Lord. What's my picture tomorrow? Let it be dismissed there. No. Lordship, because he is requesting me to make a prayer before the Lordship. That is why. Let it be
This court, by an order dated 6/3/2026, had granted time to the state respondents to file an affidavit in the matter and accordingly fixed the matter on 30/3/2026. However, no affidavit, he has come. So let us now pass the order in his presence. We set aside this requisition. We set aside this requisition.
1982.
We set aside. Okay, we should not file.
will file it.
We set aside this requisition. My question is this. Now, are you taking it for 2, 3 days? My question is this. Are you taking it only for, why do you make a requisition? Tell me. The moment you are doing it for a permanent thing, it cannot be a requisition. It's a colorable exercise of power.
That's, they have requisition and subsequently some land they have de-requisition. Some of the petitioners land they have de-requisition. And the process is going on. Lordship. The updated instruction is required, but Lordship,
We are concerned with the requisition.
requisition and some.
No, you can very well go under 9. Go ahead.
And some of the de-requisition. It is de-requisition and some setup is going on. That will not.
But you cannot initiate this type of process. No. You go under 9. Go under 9. And with your requisition, acquire them. Go under 9, acquire the land, issue a notification under 9(2), serve it to them, and it will be based upon me. But the moment you are requisitioning it for permanent purpose, you are saying what? Requisition, the land is represented so and so is for the acquisition, for the purpose of acquisition of land for so and so. You are requisitioning, saying for acquisition. How is it permissible? Tell me. Do hereby requisition under so and so the land described in the schedule below with effect on the date for the purpose of acquisition of land for so and so. Tell me. Is it permissible? Ever heard of? What have you heard? Huh? First time I've heard. We are requisitioning to acquisition the land.
But they just was initiated 54 Act. And we have the after the 54 Act, 54 Act, the protocol to initiate on a section 4 notice has been issued. And one of the subsequent process that will follow, but at that point of time, they are identifying the land. And in fact, one of in this particular in that process, I'm told that some of the land they were because not final at that point of time. Ultimately, one of the requiring authority have given us some judicial, they require them. And they, in this process, they are identifying the land, these are the land. At particular point of time, they are.
Now,
You do whatever you feel like. But you have to follow the mandate of law. How can you requisition a land for permanent purpose?
Finally, it will be acquired. That is what they have.
So acquire it. Because what happens is, once you requisition it, you keep it whenever you feel like. He can't do anything. The moment you requisition under section 3, he can't do anything. And thereby you are going to pay him peanuts.
Now, in fact, therefore, this is the identified, it is indicated that it will be required. It will be required and that process will be followed, that is coming up. So, for the time being, as per the requirement, because this is for a particular purpose for a project. They have the petition to land so that they can identify and they can go for beginning of all this they can do. And in this process, in fact, some of the land they have already dedication for that land is not required. That land is not. So during that particular transitional process, they have dedication. So by this time, my information that some of the land of the petition are.
Yeah, the moment you requisition, you take over his possession.
When the matter was filed, and I have got some instruction.
Show me tomorrow. Are you paying them some requisition amount? Which you are required to do as per section 11(12). Are you doing it? So that has to be paid as per the Assam Avenue Rent Control Act. You fix up the compensation. No.
Land is required.
No, land required is different. We are not on that, Mr. Counselor. This was done in year 2025. Yeah? 1 year almost is over. It's tragic like this. It's very tragic.
The party three, that we want to acquire the land for permanent purpose. Then second thing will come in. There will be period, the liquidation land. So with the, there you go.
Come to section 9.
Acquisition of land.
You want to do it. By that. But you can't requisition it. Just for the sake of it, for acquisition. What we are doing? We are going for 3. And then going for 6. You want to go for 3. 6 also you permit him. But if you want the land, you move under the acquisition, under section 9. You want the speedy acquisition, go ahead.
So with the permanent. What we come to here. To be good.
Now, what has been happening here, Your Lord? They are rampantly invoking this 60.
No, this cannot happen. This cannot be done.
And by this, they have subverting the process of the acquisition, Your Lordship, where I got opportunity to object everything, Your Lordship. That is not there.
Let us see why you can requisition. If in the opinion of the state or any person authorized in this behalf by the state government, it is necessary to do so for maintaining supplies and services essential to the life of the community or for providing proper facilities for accommodation, transportation of so and so, or providing so individually or in group of lenders persons so and so, or so and so formed for the benefit of rehabilitation or so and so. The state government or there, as the case may be, may by order in writing requisition any land and make such further order as is prepared to so and so. An order under so and so shall be served in the manner provided in so and so. When order of requisition of any person agreed shall file an appeal before the state government. So he has no other requirement. He cannot do anything. He cannot object to the requisition.
Is that it? In thereby, is citing party of the acquisition.
All the petitioners,
Here.
they are outside.
No, Your Lordship. Some of them land, by after filing of this writ petition, Your Lordship, some of the land has, in respect of 8 petitioners, Your Lordship, the requisition.
This is
That
under
that we have brought on record by filing an affidavit.
Then
More than that, Your Lordship, the notice itself says, Your Lordship, my name is there, everything is there. That is why I am before this honorable court. Where is the question of not being?
In fact, this is the key issue. They are doing the town court and therefore taking the petition and finally will be approving partition on.
now, what do you say about this section 3? Where rule 3, where it is necessary to requisition any land for landless people or to the person interested in the land shall be informed of the intention of requisitioning of the land, and such person will make a written representative if any within 15 days from so and so. How do you take care of this? Without informing, you just put a requisition notice? Thing is that, Thakur, in this act, while this act was being challenged before the Supreme Court, on the ground that there is no solution, on the ground that there is no immigration, the Supreme Court in a judgment in 1974-75, if I'm not
Lordship,
categorically observed
Lordship.
that if this act, the state government gave an undertaking that we are going to confirm all these things in terms of the Land Acquisition Act of 1894. And it is under such circumstances the Supreme Court did not annul this notice of requisition. So here, no notice.
In fact, this act has been put to challenge before the Honorable Division Bench.
Is it?
Yes,
Something good.
on the ground that it is not in conformance with 2013 Act. Problem.
No, this is becoming rampant. You have not filed affidavit also. Regardless of time. You should stay. Notice was issued as far back as on 12/12.
After the position for that, I will take.
No, no, first you show me where is the power. How do you exercise your power like this in respect to permanent assent? If you are going to go for acquisition, then can you do it in this manner? Without issuing a notice under Rule 3. The Rule 3 notice not that I take. No, Rule 3 is first your intention that you are going to requisition. Form B is different. Form B is, this is a notice of requisition, which is already done. That is in terms of section 3. I'm saying about you have to, prior to that, you have to issue a notice. Thereby giving him an option to object. No, it is not issued. No, I think
That's why we have not elected.
they will include what? If it is not there, anything. Let off. This court Biden that order it is 6/3/2026 that in the instant petition, the petitioners have a say. The notification, the notice issued. Under section 3(1) of the Assam Land Requisition and Acquisition Act 1964. Whereby various plots of land of the petitioners have been requisitioned. This court have perused the said notice, and it shows that the said requisition is being carried out for the purpose of acquisition. The question therefore arises as to whether For the purpose of acquisition, a requisition can be permissible. Full stop. Further to that, this court inquired with the learned counsels appearing on behalf of the respondents as to whether the mandate of Rule 3 of the Assam Land Requisition and Acquisition Rules 1965 1964 have been adhered to. The learned counsel submits that within a week's time, the affidavit will be filed. List this matter again on 8th of April 2026. It is observed that if no affidavit is filed, the stand of the state is not brought on record by filing the affidavits on or before the next date. This court shall consider passing of interim directions.
Deeply obliged.
Obviously, you don't have a case, madam. Ask your senior to stand on the next date. They are appearing for the first time before this court, so I won't dismiss it today. You don't have a case. This court grants an opportunity to the petitioner to file an additional affidavit bringing on record any document which correlate the petitioner with one to Dinesh Sonar, whom the petitioner claims to be her uncle. You never claimed the caste. Your father never claimed the caste. You are, what is your name? Swarnakar. Where your uncle whom you say is some Sonar. Your contention is Swarnakar and Sonar are one of in the same title. So that doesn't mean that you are a SC. Next time, we take it as the senior counsel not present, we adjourn. Learned counsel appearing on behalf of the petitioner submits that one further opportunity should be granted to the petitioner to file the additional affidavit. So taking into account the above, list the matter again on 6th of May 2026. So a final opportunity is given to the petitioner to file the additional affidavit on or before 4th of May 2026. It is observed that if no additional affidavit is filed, this court shall draw presumptions as regards the non-existence of relation between the petitioner and Dinesh Sonar, which the petitioner claims to be her uncle.
Message.
What is this?
This is regarding demand of value-added tax from the petitioners from the respective date. Your Lordship.
Yes, Mr. Chaudhary.
Lordship, today we have received insight.
These are what? The bar. With that case, that one case, what has happened that day? Now, I fixed for some matters together. The matter pertaining to whether a person would be entitled to, because there was a requirement of having it. The knowledge was not there in material. The fact that the law was there, the fact that they had to register themselves.
In this case, the petitioners are the registered, they have registered their businesses under the
What do you
tax.
want? You have not paid the VAT.
No, since we have received the notice, since 10/7,
10/7/2025. Since we registered our businesses, and since then we are starts collecting the VAT. But before that, as we do not have any knowledge regarding the payment of any additional 6% of it, or requirement to pay any or amendment of any act, so we did not collected any VAT until the receipt of this
Where
notice.
have you been asked to pay the VAT prior to that?
Lordship, kindly peruse the Annexure B.
Annexure?
Annexure B, page number 42.
This is for registration.
Yes, Lordship.
Why are you now going ahead to
Yes, Lordship.
putting the spade on your feet? You have registered, be happy, keep quiet. Let them go initiate any proceeding. The moment you are going ahead with this proceeding, they will do it.
Yes.
What do you want?
I want,
The moment they come up, you see there are thousands of this bar license holder. They have to pay. So this is only a direction for registration. You registered it. So then nothing remains.
we filed this case for exemption of earlier period.
We cannot be with the law say. Now they have not taken, they have to make a recovery, then come. Why you are coming now?
Because for their renewal, license renewal process was
You have
pending.
registered yourself.
They have registered, and now, after filing of this case,
Ah.
their licenses are renewed.
So therefore, you should say now it has become infectious. Infectious. And Mr. Miss So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. B. Chaudhary appears on behalf of the petitioner. Mr. B. Chaudhary, the learned counsel appears on behalf of the Finance and Taxation Department of the Government of Assam. And excise, I saw Mr. D. Gogoi. Mr. D. Gogoi appears on behalf of the Excise Department of the Government. The petitioners herein have assailed the communication dated 19/7/2025, whereby the petitioner have been directed to register themselves under the Assam Value Added Tax Act 2003. It is the case of the petitioner that in pursuance thereto the petitioners have already registered themselves and now regularly paying the taxes. Taking into account the above, as the petitioners have already been registered, the question of interfering with the impugned communication dated 17/12/2025 does not arise. This court also, during the course of the hearing, inquired with the learned counsel appearing on behalf of the petitioner as to whether any steps have been taken for recovery of the period of any amount prior to the registration, prior to the notice issued on 17/12/2025. The learned counsel submits that no such steps have been taken. So taking into account the above, this court therefore disposes of the instant petition with the following observations and directives. Insofar as the question of taking into account that the petitioners have already been registered under the Assam Value Added Tax Act 2003, there is no necessity for interfering with the communication dated 17/12/2025. Number two, as there has been no demand so made by the respondents as for the period prior to the registration, this court closes the instant petition in respect to the same issue, thereby granting liberty to the petitioner to approach in the circumstance, such levy is not to be.
Lordship, they have demanded the tax prior to
Where?
the annexure E, Lordship, page number 60. Page number 60, by notice dated 17/12/25. Page number 60. They have registered themselves in the year 2025, but this notice is issued since 2024 for financial year 2024 to 2025, 1 year earlier.
Have you replied to them?
Yes, one representation was made. Page number 66.
Then what happened?
No course of action, nothing was happened after this representation.
Let this order remain. Then you come back. Because if you want this order, I will only say that you are liable.
They will pay, but since the day of their registration, Lordship, yes, they will pay.
Where?
Yes, that they will pay.
Where is the law?
No, as per the notification dated 10/7/2025 and 17/12/2025, Lordship, as per their notifications, we are ready to pay. We have no grievance against the act.
Madam, you see, you are liable to pay on the date on which the law came in. You are liable to pay then. Because of the fact that you see, although the liquor has been is put in the first point of sale, you are why your returns are being asked? Tell me.
To see the sale,
No, you are not liable to pay the tax.
yes,
Just for example, Miss M. Bowman is the wholesaler at the bonded warehouse. At that point of time, now they are the bonded warehouse. Bonded warehouse, the moment bonded warehouse transfers to the wholesale warehouse, is the first point of sale. Is on the civil code. First point of sale. Then the tax is being paid there. The tax has to be paid then. Thereupon, when you are paying, when you are later on, the person concerned, A, now they will from there, it comes to this person concerned, Mr. Chaudhary. Mr. Chaudhary, then the wholesale warehouse tells it to you, in already tax paid. Okay? Now, when it comes to you, you sell it to the consumer. You also levy the tax. You don't separately levy the tax, but you levy the tax because what is the value you have already paid? Tax has already been paid. But when you file your returns, you will only say that you see, I have purchased these goods and this is the return, so and so. You need not pay because the tax has already been paid. The state is concerned.
only I have to
So
file
you
the
have to
return.
only submit your return. You
Returns.
don't need to pay because it is not on its part. But tomorrow, you just for example go to, you don't buy it from Gauhati, out there in any place from where Miss Bowman is selling or he is selling, you don't buy. You go to Meghalaya and purchase it and sell in you. Then it is the first sale to you. There you have paid the price. Understood?
Yes.
Therefore, you take this order and give it.
Apply.
Yes, Mr. PRC, what has happened? Eh? After the PRC, the instructions. This was before. I have the availability. There are two ways in which the council with the longest name. You see, here, a certified copy of the electoral roll of 1966 or 71 and 1997 not submit. You can do one thing, you can go and submit. But you want them to file an
Not available because our ancestor was the student of West Bengal minor.
here they give only if those people are there for last 50 years.
But my lord, yes, is required for educational purpose. My lord, what is the remedy for the petition my lord, at this stage? My lord?
Permanent residence certificate they have to be.
But they left the West Bengal my lord, in 1990 my lord. Now they are residing in Assam.
Your grandfather is there, na?
No, my lord, he died long back.
His name was there or not?
His name was in the total list of 1966 in the West Bengal total list of
Not here.
not there.
So you have never been here.
Grandfather is great grandfather.
You have to challenge this rule then. You have to challenge this rule.
Yes, my lord, now.
Related to parents and forefathers having continuously resided in Assam for a minimum of period of 50 years did not submit. Certified copy of the electoral roll or any other valid document proof of the year having continuously resided for a minimum period of 20 years not submit.
My lord.
Okay, you bring it on record by filing affidavit. Mr. So-and-so has placed before this court a set of instructions dated 2/3/2026. It is the opinion of this court that these instructions be brought on record by filing an affidavit by the state government. Accordingly, release this matter on 18th of May 2026. Affidavit be filed on or before 8th of May 2026. Liberty given to the petitioner to file reply on or before the next. Who appears for the death, COVID-19 death audit board? Huh? Health department. Health, who appears?
Actually, some records not being.
Pursuant to the order passed by this court on 2/3/2026, no affidavit has been filed by the respondent number 4. As well as the respondent number 5. Considering the above, this court fixes this matter on 29th of April 2026. This court that a final opportunity is given to the respondent number 4 and 5 to bring on record their stand in terms with the order dated 2/3/2026. Failure to do so, this court shall concede, shall pass appropriate directions for necessary compliance, for needful compliance.
This matter relates to compensation lawsuit, land acquired in 2021 lawsuit, and nothing has been paid lawsuit. This land was acquired 2021. We have submitted representation and they are silent still. And
Where is the acquired?
Gas Authority of India, GAIL.
You acquired the land.
That's what I, they have not done any document.
No, lordship. It's Page 22 lordship.
Eh?
Page 20 photograph. Page 22. Photograph and
GAIL have taken the land for what?
for installing the pipe.
Okay, so this is, has to be done under the 62 Act. Have you taken any steps in respect to the land?
That's what my doctor pointed out. And we have not done any document, so I want to some instruction from the department.
Have the petitioner given the details of his land?
No, they have not taken.
No, lordship, we can,
They have not done any notice.
no, lordship,
The lordship has-
notice, nothing was
last
submitted.
note Reflected.
No. Lordship, they without any formalities, they have taken the
And
land
yes.
lordship. We approached lordship, it's a very common people. It was assured that the fund will be available, they will get the compensation. I have stated lordship. And lordship, page 20 is my representation dated 10/11/25 lordship. And this was duly received by the authority lordship. Kindly see page 21 lordship.
Only my lord, that was their, pipeline, you have the land or opposite the land, pipeline district, that portion they definitely. Because that land never fall under the, and yes, it is Marlin, they. Before the cycle.
Yes, revenue. Revenue is the party.
Yes, lordship.
Revenue, just find out as to whether this, what land has been allotted to these petitioners by this communication. No that number or whatever it is, there they have given this land. No, page 14 is otherwise not a type.
Our representation is there, lordship, page 20.
Nothing done.
13. 13.
No, that is not.
No, original is there.
What is it now?
Page 14 lordship. Allotment.
In the case of the petitioners, that the petitioners were allotted 6 figures, 4 katha, 19 letters of land by allotment certificate dated 15/6/1976. Record bracket 29/6/1976. Bracket by book number 1000, serial number 49973. Under Tozi Patta number 9, bearing dark number 293/543 of village Athinapur, PO Bongaon, in the district of Bozali, Assam. The respondent number 4 and 5 is directed to ascertain as to whether such land was allotted to the petitioners. And further, whether any pipelines have been laid by the GAIL, by the general, yes, by the Gas Authority of India Limited on such land. A report be placed before this court by filing an affidavit on or before 18th of May 2026. List the matter again on 25th of May for 2026 for an update. But we'll see later. First, let them find out if it is so.
But in their petition, they stated that they have already rejected their prayer. In the petition, page 8.
Yes, sir.
The insurance stated
Before the circle officer, everybody, but the same was rejected, same day completion not taken.
That is why, Lordship.
Mr. Mitra, if you were on the other side, I would have been more strict. But we have to be lenient sometimes when it is the case of a person who is disabled or not in a position to approach this. We have to be lenient. Okay.
My lord, I have a plot of land, my lord. I want to sell it out, my lord. I want to sell it.
I need some time to file our objection.
Let me place my case, whether objection would be do anything.
Okay.
My lord, what happened, my lord? I have a plot of land. I want to sell it out. I have entered into agreement also. Ask for NOC. My wife filed objection. My objection, my wife filed
Where are
objection
you?
that NOC should not be issued.
What is your name?
My name is Nur Mohammed Sarkar. So my lord, what happened? Objection, not family dispute. My lord, land should not be sold. Thereafter, what happened, my lord? Against that objection, I filed a petition that objection may be undone with. The deputy commissioner did not do it. Then I came before your lordship. Then your lordship directed that dispose of this petition. Petition, after getting that direction, my lord, petition is disposed of by impugn order, my lord, at page 53. Circle officer said that I cannot do anything because it is a family court. Your lordship will turn to page 53.
In and peruse the petition submitted by Chancellor regarding care for withdrawal of objection against issuance of the insurance. In the hearing.
Yeah,
conducted
district
at
commission,
settle-
sorry, madam.
settle the issue on demand, it came to light that objector is the with the wife. But the provision is not a recorded to both the husband and the wife. As such, the objection cannot be withdrawn. You can. The petitioner is required to approach the competent authority to redressal of the ruling. Yes. No, what are you doing? Huh? What objection? Objection given by the wife, you have nothing to do with that. No, you are going to do all this thing. They say, no, your basis is to see as to whether he's the owner of the land or not. Wife says has nothing to do. Wife has said that, okay, if he sells the land, where will I go? Are you therefore going to exercise your 21A on that basis? No. Please, think which can. No, kindly see the order at page 53. Where does it say? In the hearing conducted to settle the issue on so-and-so, it came to light that the objector so-and-so is the wife of Nur Mohammed. Although woman is not the recorded pattadar of the land, both husbands are in dispute related to the property. What dispute can it be? What right do you have?
Objector may not choose a wife, and wife is objecting for the sake of their children.
Therefore, can it happen? No. We dispose it of tomorrow at 2. With the matter tomorrow at 2.
Obligation. Next week, man. 2 more months. Already I am suffering. I have to file our objection.
Not
A
bothered.
lot of,
We are not bothered.
there are many things happened, my lord, between the. wife
Many
and-
things, he may get the maintenance on it.
At least, my lord, 7
Not my
petitions
land.
are pending.
Maybe.
These type of matters we need to finish.
Obligation.
Yes, Mr. Council, the next one. Yes, Mr. Gupta, what is this?
My lord, page 34 is the impugn order, my lord. In demolition, notice has been issued by the GMC for unauthorized construction, my lord. There was already an existing structure, my lord, which was existing. Thereafter, the petitioner undertook, my lord, construction of an Assam type house, my lord, but that is without permission.
GMC is not here, na?
My lord.
We extend this order, no, pretty much fine. It's noticed that this court by an order dated 2/3/2026 and issued notice. No affidavit has been filed on behalf of the respondents. Accordingly, this court fixes the matter on 18th of May 2026. The interim order passed on 2/3/2026 shall continue in the next date. It is further observed and directed that the respondents shall in the meantime bring on record the stand by filing the affidavits on or before 11th of May 2000. Yes, Mr. Bora,
The eviction matter.
what has happened?
Nothing at the
What are you
Corner
doing here?
Authority wants to evict me, but if you notice annexure 13, page 83 issued. And thereafter, despite having stay order of the honorable court, they evict me
When?
on 13,
13/3.
13/14 eviction drive continued. And my lord, if you know the order dated 12/3/2026.
You say that you have been evicted on 13/3.
Yes, next day,
You file an additional affidavit.
I filed, but hurriedly, I have collecting the evidence. I will file affidavit. Next day,
File a contempt also.
yes, I'm ready.
The council appearing on behalf of the petitioner submits that though there is an interim order passed on 12/3/2026, and the same was duly brought to the attention of the respondent. But the respondents have evicted the petitioner on 13/3/2026. You would like to bring on record the state respect by filing an affidavit. Taking into account the above, when do you want it?
Thought date may be given
When
before view. Before view. If possible.
No date only. You have asked the court to get closed on 10.
Your lordship,
9th, you are having the election. Then on 22nd of April 2026, interim order passed earlier. Shall continue.
Eviction from Pasta land under chapter 10 of the Assam Land Revenue Regulation. There is a
Yes.
stay order operating money in the last occasion.
How did you purchase in 1982?
1982.
How?
The
Whether the power contained in the 165 was not there.
To answer that question, my lord has seen 164, my lord. The first of all, if my lord uses the order of eviction, it says, my lord, perhaps the eviction order is also perverse because it considers only one class of people, protected classes, my lord. But 164, the proviso 164(2) also speaks about permanent residence.
My question is no. My question is,
Yes.
how did you at all purchase in 1982?
That was my pleaded case, my lord, that we, the petitioner, belongs to the Goria community of Assam, my lord. And they have been the original residents of Jalukbari, Dokhin Rani, that area, my lord. Now, since they were original residents, my lord, a sale deed was executed
in
favor of-
1982.
In favor of the father, my lord. Now, a landholder can transfer land either to someone who belongs to the protected class or someone who's a permanent resident of that area. Now, if he's a permanent resident, well, there are two yardsticks. The deputy commissioner has to give a special permission and he has to see whether by giving that permission, he's not prejudicing the backward class. Now, the permission is not with me, my lord. But my lord, there will be a presumption of regularity of official acts, my lord. Because
No, not possible. Because first, for the right to be there is a bar. So,
for landholder, land was transferred from a landholder.
but I think we passed those orders which we normally pass for tribal land.
But here, my lord, the case is different because Patta land, my lord, since 1980, the land has been located.
Patta, non-patta,
I will say
the tribal land. Who then?
that aspect has to be managed.
Why should we do
After
that?
approving vacation, my lord, we will stay order.
Any order that passed, go there. Look into it, show 155. But anyway, not today. We'll pass the order. Who is going to produce the private land orders?
Well, nothing will come up after the vacation. But no, let them.
We'll come up tomorrow at 2. And finish it up. Familiar order too. This is nothing to do. Why should I look into it? They will look into it. The district commissioner, the co-district commissioner, they will look into it. And if you show them, yes, it is there. Why should we go into those respect? Show them that the BC has given a permission and all those things.
Yes. There is no complete bar. That's my
That
submission.
is a complete bar. There is no equivalent of the Indian bar. Yes, if you were there, you are there out there, your electoral ID will be looked into, they will look into. Why should we look into? List the matter tomorrow for final disposal at 2 p.m. In time or the faster we can continue. Because you will be getting 60, 80 days, whatever may be, how much day time. That is your lookout. And if you are able to show. What is this? Affidavit file?
Not said today only I have received instruction.
Last opportunity given, na? To order the license. No opportunity file. Will be not file.
No, but today only I have.
What is the matter, Mr. Counsel?
Well, we executed both contract matter, the PMGSI, the road construction matter. That our claim is that along with the field matter, the authority should also add the GST. Now, our contention is that this position has been covered by coordinate based judgment matter, that they are disputing on facts. That's why the affidavit are court asking to find. The same point has been decided.
Here. Is by an order dated 12/3/2026, the court had granted the PWD authorities a final opportunity a last opportunity to file the affidavits. However, no affidavit has been filed. Considering the above, the instant proceedings, this court shall proceed with the instant petition only on the basis of the materials which are available as on date before the court. This is matter for final disposal on 22nd of April 2026. The respondents, PWD, are debarred for filing.
Also can take this.
Debarred from filing any affidavit.
The petitioner's property, your lordship, the land and this building was acquired and by the respondents for the construction of Assam road under Assam Hola. But initially, your lordship, they came out with a survey, your lordship, wherein they have said, your lordship, my land falls in under dock number 61. And they have also stated about the valuation of the building.
7,22,635.
The initial value was 12,42,515. That was.
Now they
the
are,
lordship will
you are
file-
going to pay how much?
We have
7
filed
lakh.
our appeal.
You're going to pay how much? 7 lakh
Yes, lordship, 7,02,635.
in respect to the building.
Yes, and because the land, as because the building is in the government land. So that value will be.
Your lordship, your lordship, move on to page 15. Your lordship will find your lordship. This says your lordship, my land is, my land, the task number of the land was page, 61. Above your lordship will see column 3. The value assessed by the PWD department was 12,42,550. Now they are saying, your lordship, that the land was, they didn't, there was some mistake in assessing the land.
This is Patta land.
Your lordship, my claim is that it is a patta land. And they also initially said that this is a patta land. It fall under doc number 61.
Where is the Patta?
Your lordship, your lordship, your lordship. I've not annexed the patta
No,
here, but
no, no.
your lordship, then your lordship, they have come in the affidavit in opposition saying that my land fall under doc number 60.
Which is a government.
Then I have filed an RTI. In the RTI, they says that my land fall under doc number 59. That I have annexed in my reply. Your lordship.
59 is also this land,
Yes,
government land.
government land. Your lordship, now the PWD may be wrong in assessing the doc number of the land, but
This acquisition is done under what? Some
Assam.
mala to it can't happen. You cannot unilaterally, if he agrees, don't agree, then it has to go. Some mala cannot, you cannot force. You can force.
No.
Then you have not agreed.
no,
No.
the value.
Then they will have to go as per law. They think that affidavits have been filed. The pleadings have been exchanged in the instant proceedings. This court inquired with the learned counsel appearing on behalf of the state respondent as to under what provision the land has been acquired. It has been submitted that the land is being acquired on the basis of the Assam Mala scheme. This court inquired with the learned counsel appearing on behalf of the respondents as to whether the Assam, any acquisition can be made
RCC building falls in a government land.
under the Assam Mala project, thereby affecting the properties of, immovable property of a person against his interests. The learned counsel submits that he would obtain instructions in that regard. List this matter on 22nd of April 2026. You go do whatever you feel like. You have to do it. You cannot later on. Yes, what is this matter? Yes, madam.
The premium, there the deeds were not recorded and patta was not delivered after filing. Deeds were recorded in the patta not yet.
Has been issued.
No, madam, it is waiting for approval from the.
It has been submitted by Ms. Embalmment that the patta would be provided to the petitioner when the digital patta service is fully functional and implemented in the DC level. This court, however, inquired as to when such services could be available. The learned counsel submits that she has no instructions in that regard. list this matter on 24th of April 2026 for an update. Liberty given to the petitioners in the meantime to file reply to advice. What are these? What are these?
Disqualification method.
Huh?
Disqualification.
Ah,
But under lordship order.
what? Huh? Who will argue? Okay. What are these judgments? We can dismiss it when? When you got that, have you got my other order, another aspect?
Well, the earlier order, my lord,
The
I said.
earlier order you got here, but their next order,
Not yet.
yeah, up to rule. You must the series to panchayat up to rule. Actually, I gave it, it's already signed and all, I'll give it in. But the fact remained that when I went to Kohima, all my stenographers also went on hanging.
I'm eagerly waiting for those.
Huh?
Eagerly waiting for those.
Because there, another aspect has been mentioned as to, as regards what will be the effect of Isa Khatum on this time. But anyway, we have it, let's have it on Thursday.
Thursdays.
This matter on Thursday at 2 p.m. for final response.
Hello.
Okay. Same order passed earlier.
What in time? What in time order is passed? What in time order is passed?
The election, everything was there. Then I was disqualified by the deputy commissioner. That is stayed by the company.
Oh, is it? Oh, I am in your favor.
Yes.
Okay, in time order passed earlier shall continue to do it.
Hello.
Petition would be allowed. One petition would be allowed, other would be infractions.
Which case in the interim order should I allow?
In 51, that is in my name, journal of the.
Journal of original 51, huh? It would be mine. Next.
One of the matter pertains to the non-returning of my cultural documents. Lord, may kindly have the order date is 28/3, the last order.
What is this matter? Non-returning the original deeds.
Yes, my lord.
Yes, Mr. Sharma, why haven't you returned? Why you are not returning?
No, your lordship, the case is that the father, that the husband of the petitioner has taken a loan. And that loan has been squared up in the year of 2021. But there was another loan, that is of Pinky Sekia, who is the daughter of the petitioner number 1. And in that case, the late father.
Whether this land was mortgaged?
Yes, yes. Okay. So I may be allowed to bring it on affidavit.
You have filed affidavit.
No, your lordship.
So that 5,000 is there, we impose another 5,000.
No, your lordship, only today I have got the information. Your Lordship.
No, you cannot. Earlier the 5,000
No,
is
earlier
imposed
your-
for that.
Only on the
So
last date.
today also you have not filed.
No,
Another
today,
5,000.
after searching of your lordship, I have got the information only from the DRT side.
At the request of Mr. M. Mr. M. Sharma submits that the cost of rupees 5,000 has already been deposited
Today only.
today. Puster. This court further, he further submits that the non-returning of the original document is on account of there being another loan wherein the same property have been have been mortgaged. Puster. It is the opinion of this court that the said aspect be brought on record by filing affidavit on or before 22nd of April 2026. This matter again on 30th of April 2026. Yes. Any matters where you require some orders to this? Yes, what are the? Yes, Mr.
Item number 54 may be fixed on 2nd of April, my lord.
What is this matter about?
This is the LIC case, my lord, regarding repudiation of LIC claim. This is the case of 2016, my lord.
Yes, you were to obtain instructions as to whether.
Yes, my lord.
My lord, I have filed a reply, my lord. That reply indicating that, my lord, the cause of death, my lord. That is not,
Oh, that matter.
yes, my,
Or whether it is required, you can remove the response number 5.
yes, my lord, that on last occasion, that was the observation by your lord.
And did you file an additional?
Yes, my lord, I have filed the affidavit in reply.
Okay. The matter has been heard in substance.
Yes, my lord, yes, my lord.
Item number 54. Mr. D. Bora, the learned counsel, D.P. Bora.
Yes.
The learned counsel appearing on behalf of the petitioner submits that the petitioner would not like to insist on the presence of the respondent number 5 in the there's an I.
Yes.
Would not like to, did you withdraw the I?
Yes, my lord, on last occasion, it was observed that, my lord, that may be closed, my lord. that I-
Okay, and close the I. I close it. Close it. It will be safe. Mr. D.P. Bora, the learned counsel appearing on behalf of the petitioner has submitted that the petitioner have already filed an additional affidavit.
Affidavit in reply.
Affidavit in reply.
Reply.
Good stuff. You are okay?
Yes, sir.
Taking into account that the matter had been substantially heard. Who appears for the other side? Taking into account the above, list this matter again on 5th of May 2026. In the meantime, the respondents, it's so advised to be at liberty to file in reply. In a rejoinder to the said affidavit. Because he must have brought in a new thing, no?
Yes,
He informed Mr. Chatterjee.
yes, my lord.
Yes, Mr. Modi.
The PVC claim. After your lordship passed the judgment, we raised a specific bill in terms of your lordship judgment. That bill they have not paid. They are saying that we have completed. That figure.
Reply everything complete. It is submitted that the pleadings are complete in the instant contempt application. Accordingly, list this matter on 23rd of April 2026 at 2 p.m. for final disposal.
My lord, I don't know, 43.
43.
Review, I would be out of it in the month of April.
Anyway, I'm not going to review that order. I'm not going to review that order. I want it when? This year, next year, when?
Whatever may be, my lord, your worship will hear me.
No,
Sir, let it,
I will. Yeah, when do you want it?
first week of May.
Next year?
No, in this year,
No.
I would be out of it this month.
You be okay.
In the month of April, man.
Let's this matter again on. You are going to Rajasthan when?
On third.
And coming back?
I will come back in the last week of
April. Okay. Let's this matter again on 19th of May 2026.
Item number 45, madam. This petition was for the extension of the stay order which was granted earlier, madam. My lord, due to some inadvertence, it did not get, my lord, extended on 13/3, 2023. And I was also not there.
45 period. Who is there? You are there?
R. Babu was there. Was fixed on 13th, my lord, of this month for the purpose of, my lord, records by the government. But I was not there, my lord. I had circulated an adjournment slip, my lord, and my lord, on that day mention was made, my lord. The interim protection given by the order dated 11/2/2026, that may kindly be extended, my lord.
Or Mr. So and so, the learned counsel appearing on behalf of the petitioner or the applicant. Mr. So and so who appears on behalf of the respondent numbers. Respondent numbers 1, 2, and 3. 2 and 3. 3 and Mr. Eviction appears for respondent number 1 and 2. Corporation Department Estate Alundra. And AR for respondent number 2. There is an application saying for extension of the order dated 11/2/2026. Taking into account that no affidavit has been filed on behalf of the respondents till date, affidavit filed by till date comma. This note disposes of the instant application directing the parties to maintain status quo as regards as on today, as on today, that is so and so, as regards the possession in respect to the land mentioned in doc number 182 of village Kandikar, lot number 7 under Moza Lokrai within the revenue circle Sipaja in the district of Darang. So this status quo order shall continue till 11th of May 2026. I stands accordingly disposed of.
Because the paragraph number 12 is in the order.
Wait. 15, A2 main petition here. This court had offered status quo as on today in respect to his real and political. This interim orders can continue till 11th of May 2026. Respondents in the meantime are directed to bring on record their stand by filing the affidavits. List the matter again on 11th of May 2026.
That part where they were allowed to carry on with their claim and getting all that is on the order dated last part of the order dated 11/2/26.
Status quo.
Status quo was there, but that was in addition, madam.
That is there.
Part kindly, madam, mention it, madam. There's been a big political custom, madam, in this matter, madam. Kindly, that line, madam, which was there in the order dated, madam, 11/2/2026.
No,
That may kindly
I
be
have to
added.
pass a space order now. I
Madam.
passed before status quo as on today.
May I please, the lordship? My lord, item number 41, my lord. There is an interim, my lord, till returnable date. My lord. Item number 41, my lord. That may be extended, any date may be fixed, my lord.
Okay, the service upon the respondent number 6 and 7 being complete.
6, yes, my lord.
But list the matter for admission again on 6th of May 2026. Interim orders passing earlier shall continue till the next.
Obliged.
Yes,
Madam, I don't know, particular madam. Madam, the review for, madam. It's other madam. Others have got the relief, madam. I'm still what is good. My date, madam.
okay, list the matter again on 22nd of April 2026 at 2 p.m. for finance.
Well, the item 44 is a review of the state. But I take it.
What matter is this?
Well, that it's a tender matter well, of the, it's a tender issued by the veterinary department. Lordship has directed us to bring the tender to a logical conclusion. Well, to bring the tender process to a logical conclusion. Well, after the lordship's order, well, the committee has evaluated the documents and they found that some vital certificates which are required as per the tender documents were not given. And the earlier, while assessing the bids, tender documents, the earlier evaluation committee, they left out.
We do this thing, one thing, 44. 44. We let us have it on 21st.
Can I pay for before the vacation? Can I pay for before the vacation?
I can, but all these days it's very difficult. See, 6th, I am not there. 7, 8, 2 days. 9th, you are getting it closed because of yours.
Not.
10th is closed.
10th.
Very difficult. And 1st and 2nd, or these are all motion days.
Not.
So let us have it on 21st.
Not.
Or we can do one thing. Let's have it on the 2nd at 2 p.m. for final disposal.
Yes. Well, this has come for the first time. This has come for the first time.
Okay.
Notice.
Okay.
Then we have
It's the matter so and so on 2nd at 2 p.m.
Mal.
Anything more?
Lordship, item 37, similar prayer, Lordship. This is a review matter, item number 37. Any
Okay,
date.
that will be on
22nd,
23rd. 23rd at 2 p.m.
I'm so.
Review.
With the pertains to a transfer of prisoners, signal break.
40.
40.
Service being complete. List this matter again on 22nd of April 2026 for admission.